sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private Bond Court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond Court is now in session.
All right, and can we have Claudio Perez?
Claudio Pérez.
He wants both of them.
Right here.
One. Get her over the other side.
All right. This is 22 CF 6781, Say versus Claudio Perez. Mr. Perez, and Madam Interpreter, he's going to need the interpreter. So, Mr. Perez, can you state your name?
Señor Pérez, ¿nos puede decir su nombre, por favor? Claudio Pérez.
Sir, I have an affidavit here. The court, having reviewed that affidavit, finds that there is probable cause for the offense of false imprisonment and battery, domestic violence.
Señor Pérez, aquí tengo el affidavit acusatorio. Hallo que hay causas que respaldan la acusación de haber retenido a alguien con pretextos falsos y la acusación de agresión.
Having found probable cause, Ms. Espinoza, you are the alleged victim in this case. Let's have her sworn in.
Señora Espinosa, usted es la alegada víctima en este caso. Por favor, levante su mano para prestar juramento.
Please raise your right hand.
Levante su mano derecha.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Solemnemente jura o afirma que el testimonio que está por presentar es la verdad y nada más que la verdad. Perdón, repita.
She doesn't need the interpreter, he does.
Oh, okay, I'm sorry.
It's okay. But she said I do, so if you want to interpret for him.
Lo juro.
All right. And ma'am, could you please state your name?
Señora, por favor, díganos su nombre.
My name is Ileana Espinosa.
Mi nombre es Ileana Espinosa.
All right. And defense, did you want to inquire?
La defensa, ¿quiere hacerle alguna pregunta?
Yes, Dominique Cunningham for the record, Your Honor. Ms. Espinosa, do you want contact with Mr. Perez? No.
Señora Espinosa, ¿usted quiere contacto con el señor Claudio Pérez?
No further questions, Your Honor.
I'm sorry, Your Honor, the interpreter did not get a response.
She said no.
Ella ha dicho que no.
And State, did you want to inquire?
¿El fiscal quiere hacerle alguna pregunta? No, su señoría.
Ms. Espinoza, whose residence, or do you all share a residence?
Señora Espinosa, ¿ustedes comparten una vivienda?
I'll speak. It's under both of us, but I'm the one that is being paying for it for the past months.
Es el hogar de ambos de nosotros, pero yo soy la que la he estado pagando por el último mes o los últimos meses.
He hasn't lived in there for three months already.
Él lleva 3 meses que no ha estado viviendo ahí.
All right. Any follow-up defense?
No, Your Honor.
Además de la defensa, no, su señoría.
All right. Defense with regards to release as it pertains to Mr. Perez.
Defensa
Your Honor.
en cuanto a la libertad, a lo que se refiere del señor Pérez.
Your Honor, we'd be asking for a reasonable bond in this case.
Su señoría, estamos pidiendo una fianza razonable en este caso.
And we'd also like the court to take into account that Mr. Perez is also a listed victim, and Ms. Espinoza, her report states that Mr. Perez held on to her hitting him.
I'm sorry, Your Honor. The interpreter is going to ask for a repetition, please.
I apologize. We would like the court to take under advisement that Mr. Perez is also a listed victim.
Queremos que el juez tome en consideración que el señor Pérez también ha sido listado como la alegada víctima en
And
el caso de ella.
And the report for Ms. Espinoza, it states that Mr. Perez held on to her to stop her from hitting him.
Y en el reporte de la señora Espinosa se menciona que el señor Pérez la aguantó para que no le hiciera daño.
And in the end, Ms. Espinoza was also arrested for hitting Mr. Perez, so we'd like the court to take that into account.
Y la señora Espinosa también fue arrestada, detenida por haber golpeado al señor Pérez, y por eso queremos que tome esto en consideración.
All right. As to count one, the court will set bond at $250. As to count two, the court will set bond at $250. The court will make the conditions of bond as follows: no contact with the victim, maintain a separate residence who is not to return to the residence. He'll be required to not possess any weapons, any firearms, or any ammunition. I believe those are all the conditions of the bond.
Bien, el juez va a tomar la siguiente decisión. En la primera causa, la fianza es de $250. En la segunda causa, la fianza es de $250. Condiciones de libertad bajo fianza. No puede tener ningún tipo de contacto o comunicación. No puede regresar a la vivienda. Tiene que mantenerse separado, viviendo separado. No puede poseer ningún tipo de armas de fuego, municiones. Y tiene que cumplir con todas las condiciones de libertad.
And did you want a one-time return to the residence to collect any personal belongings?
Yes, please, Your Honor.
¿Usted quiere que se le otorgue el poder regresar a la vivienda en una sola ocasión, acompañado de un oficial de la ley de las autoridades para retirar sus artículos personales? Sí, su señoría.
All right, I'm going to grant that request. I will give him a one-time return to the residence accompanied by law enforcement to retrieve any personal belongings.
Bien, se da lugar a esa petición. Se le va a permitir regresar a la vivienda en una sola ocasión, acompañado con un agente de la policía, para retirar sus artículos personales, nada más.
And I will appoint the public defender to represent him.
Y se le designa la Oficina de Defensores Públicos para que le represente.
All right, 2022 MM250 State versus Eliana Espinoza. Ms. Espinoza, the court has reviewed the affidavit, finds that there's probable cause for the charge of domestic violence battery. Does the victim wish to be heard? Does the defense want to call Mr. Perez?
No, Your Honor.
All right, State, do you wish to inquire of Mr. Perez?
No, Your Honor.
All right. As to this offense, defense, you wish to be heard with regards to release?
Yes, Your Honor. We'd also like the court to take into account that Ms. Espinoza is listed as a victim in Mr. Perez's case. So we would ask for the court to take that into consideration, considering the bond. And we'd also think that a no contact order is appropriate in this case as well.
All right, Ms. Espinoza, I'm going to appoint the public defender to represent you in this case. I'm going to set bond at $250 on count one. The conditions of bond is that you have no contact with the victim and that you not possess any weapons, firearms, or any ammunition. You do have a warrant from Sumter County. The court will execute that warrant at this time. Those are for charges stemming from a false name or identity to law enforcement and driving while license suspended. The bonds in those cases were set at no bond. They will remain set at no bond. You can request that the judge in Sumter County set bonds on those cases. All right, ma'am?
And Your Honor, just to clarify for the battery, what was the bond?
$250, no contact with the victim, and no weapons, firearms, or ammunition.
Thank you. Wait one second.
No, because, she'll be allowed to return to the residence because he's not. So I'm not making that a requirement of her bond. But they will be required to maintain separate residences.
Thank you, Your Honor.
All right. Yuli Anez Rincon.
Approaching, Your Honor.
Ms. Inez Rincon, is there any victims in the gallery with regards to Ms. Rincon's case?
Estamos aquí en el caso de la señora Anés Rincón. Anés Rincón, ¿hay alguna víctima aquí presente en la galería en el caso de Anés Rincón? Here, yes, Your Honor, there is.
All right, sir, please come forward.
Hacia adelante, por favor, señor. ¿De necesidad de servicio del intérprete?
Sí.
He will be the services of the interpreter as well, Your Honor.
All right, sir, please raise your right hand to be sworn in.
Derecho, por favor, para prestar juramento.
You solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Correct.
All right, thank you, sir. Defense, do you wish to inquire?
La defensa de la señora.
Yes, Your Honor.
Sí, su señoría.
1 second, hold on. Can you please state your name for the record?
Decir su nombre para las actas.
Gerardo Rosales.
Gerardo Rosales.
All right, you may inquire.
Sir, would you like to have contact with her?
¿Quiere poder tener contacto, comunicación con ella?
Sí.
Yes.
Are you scared of her?
Or my children. ¿Usted tiene temor? ¿Le tiene miedo a ella? No.
Would you hesitate to call law enforcement if an incident were to occur again?
¿Usted estaría dispuesto a llamar a las autoridades si un incidente como esto volviera a ocurrir nuevamente? Yes.
You would not call law enforcement?
¿Usted no llamaría a las autoridades?
Sí.
Yes.
I'm sorry, I just want to clarify. Could you just state whether you would or would not call 911?
Ella quiere aclarar. Por favor, díganos, ¿usted estaría dispuesto a llamar al 911, sí o no?
Yes.
Yes.
Okay. How old are your children?
¿Qué edades tienen sus hijos?
Uno de 3 meses y uno de 4 años.
I have a 3-month-old and a 4-year-old.
And does she help with the care of those children?
I'm sorry, could you repeat that for the interpreter, please?
Does Miss Anez Rincon help with the care of those children?
La señora Inés Rincón ayuda para el cuidado de esos niños.
Sí.
Yes.
No further questions, Your Honor.
No tengo ninguna otra pregunta, su señoría.
State.
Yes, Your Honor, we have a couple.
Sí, señor. Tenemos un par de preguntas.
What's your relationship with the
¿Cuál es su parentesco con la acusada? ¿De qué relación tiene?
Un esposo.
Legalmente casada. Husband and wife.
Has there been any past violence?
¿Ha habido alguna violencia en el pasado?
And how long have you guys lived or been together?
¿Cuánto tiempo han estado viviendo juntos o han estado juntos?
Aquí en Estados Unidos tenemos 2 años juntos. Tenemos 5 años.
Here in the United States, we've been together 2 years, but we've been together 5 years.
So has there been any past batteries or anger towards anybody else but you?
En el pasado, ¿ha habido algún tipo de agresión o enojo aparte de contra usted? ¿Contra alguna persona?
No.
No.
No further questions, Your Honor.
No tengo ninguna otra pregunta, su señoría.
All right. With regards to release, and the court would note that the defendant does not qualify for PTR defense.
Pues haya que para el programa de PTR.
Your Honor, we would ask for a minimal bond in this case, taking into account the testimony.
Estamos pidiendo una fianza razonable en este caso.
As well as the fact that they do have young children together.
Y por el hecho de que tienen niños pequeños juntos.
And there is no history. It looks like the reason she doesn't qualify for PTR would be her immigration status.
No hay historial y aparte de en la cuestión de inmigración, ella pues pudiera ser elegible para el programa de PTR.
And we'd also ask for no hostile contact.
También estamos pidiendo que se le permita tener contacto que no sea hostil.
All right, state.
Bien, el fiscal.
The state would ask for a $250 bond, Your Honor.
El fiscal está pidiendo una fianza de $250.
All right, the court will set bond at $250. The conditions of bond will be that the defendant not have any hostile contact,
Bien, se va a establecer una fianza de $250. Condiciones de la fianza es que no puede tener contacto hostil con la víctima.
that means you're not to yell at him, you're not to use offensive language towards him, you cannot put your hands on him without his permission. You understand that, Ms. Inez Rincon?
Esto quiere decir, señora Anés Rincón, que usted no puede gritarle, no puede usar palabras obscenas contra él y tampoco le puede poner las manos encima. ¿Entiende esto, señora Anés Rincón? Yes, sí.
All right, the court will also impose a condition that you not possess any weapons, firearms, or ammunition.
La Corte también le impone la condición de que no puede poseer ningún tipo de armas mortales o municiones.
All right, thank you.
Bien, gracias.
Muchas gracias.
Thank you very much. Thank you.
All right, Alfonso Hinojosa Aguilar.
Approaching Your Honor.
All right. Mr. Hinojosa, the court finds that there is probable cause for the offense of domestic violence battery.
Señor Hinojosa, el juez halla que hay causas que respaldan la acusación de agresión, violencia doméstica.
Are there any victims present with regards to Mr. Hinojosa's case?
¿Tenemos alguna víctima presente en el caso del señor Hinojosa?
There is no response in the gallery.
No hay respuestas en la galería.
Defense?
Your Honor, we would ask for minimal bond in this case, taking into account that Mr. Aguilar, his history is very minimal. It looks like there was a conviction in 2009 for no valid driver's license. Other than that, nothing else. So we'd ask her to take that into account.
All right, the court would note that he does not qualify for PTR. State?
Based on his lack of history, Your Honor, the state would ask for a $100 bond.
La abogada de la defensa ha pedido una fianza mínima y que el juez tome en consideración el historial mínimo del señor Hinojosa, pues han sido casos de cuestión de manejar, de licencia de manejar. Él no es elegible para el programa de PTR y el fiscal está pidiendo una fianza de $100.
All right, the court will set bond at $100 with the following conditions.
El juez va a establecer la fianza en $100 con las siguientes condiciones.
No contact with the victim.
No
Return to the residence.
No puede tener contacto con la víctima, no puede regresar a la vivienda.
Maintain separate residence.
Se tiene que mantener viviendo por separado.
And the court will allow a one-time return to the residence accompanied by law enforcement to retrieve any personal belongings.
El juez le va a permitir regresar a la vivienda en una sola ocasión acompañado por un agente de la autoridad para retirar sus artículos personales.
All right. All right, thank you, sir.
Gracias, señor.
All right, Eduardo Salgado Lagos.
Come on, Eduardo.
All right, sir, please state your name.
Señor, su nombre, por favor.
Eduardo Antonio Salgado Lagos.
¿Podría repetir nuevamente, por favor?
Eduardo Antonio Salgado Lagos.
Eduardo Antonio Salgado Lagos.
All right, Mr. Salgado Lagos, the court finds that there is probable cause for the offense of battery domestic violence based on the affidavit provided.
Bien, señor Salgado Lagos, el juez halla que hay causas que respaldan la acusación de agresión, violencia doméstica.
All Are there any victims present with regards to Mr. Salgado Lagos?
¿Tenemos alguna víctima presente aquí en el caso del señor Salgado Lagos?
There's no response in the gallery.
No tenemos respuesta en la galería.
Defense, the defendant does not qualify for PTR.
A la defensa, el acusado no es elegible para el programa de libertad preventiva.
He was severe. Go ahead.
Based off of his lack of history, we would ask for a minimal bond in this case.
Dado al historial mínimo que él tiene, estoy pidiendo que se le dé una fianza baja.
State.
State would ask for a $500 bond, Your Honor.
El fiscal está pidiendo una fianza de $500, su señoría.
Your Honor, if I may,
May.
we would ask for a lower bond in this case. It looks like the reason why he doesn't qualify for PTR is because community ties couldn't be verified as well as his legal status. Again, Your Honor, he does not have any past history, so we would ask for a $250 or a $100 bond.
Su señoría, la razón por la cual estamos pidiendo una fianza más baja es porque él no es elegible para el programa de libertad preventiva por lazos que le aten a la comunidad, no poder ser verificados y por su estatus legal. Él no tiene historial, por eso es que está pidiendo una fianza de $150.
All right, the court will leave the bond set, or will set the bond at $500. The conditions of bond is that he not have any contact with the victim. He will be required to maintain a separate residence. He will be allowed a one-time return to the residence to collect any personal belongings, so long as he's accompanied by law enforcement.
Bien, el juez va a dejar la fianza en los $500. Se le ordena como condición de libertad no tener ningún tipo de contacto con la alegada víctima, tiene que mantenerse separado de la víctima. Se le va a permitir regresar en una sola ocasión acompañado de un agente de las autoridades a retirar sus artículos personales, nada más.
You're not to possess any weapons, any firearms, or any ammunition.
No puede poseer ningún tipo de armas, armas de fuego o municiones.
All right, thank you, sir.
Gracias, señor.
Josué Ruiz Gomez. All right. Sir, could you please state your name?
Señor, por favor, díganos su nombre.
Josué Eduardo Altegundo Ruiz Gómez.
Repita, por favor.
Josué Eduardo Altegundo Ruiz Gómez.
José Eduardo Altequiros Ruiz Gómez.
All right. Mr. Ruiz Gomez, there's a warrant for your arrest on a failure to appear for possession of cocaine and driving while license suspended. Bond for both of those counts were set at zero bond. The court will leave those bonds as previously said, appoint the public defender to represent you.
Bien, señor Ruiz Gómez, usted está aquí por no haber compadecido en corte en un caso que tenía de tenencia de cocaína y haber manejado con la licencia suspendidas. En este momento la fianza de cero se mantiene igual. Se le designa al defensor público para que le represente.
Sir, you can request that the presiding judge in that case consider bond through your attorney.
Señor, usted puede hacer una petición a que ese juez que está asignado a su caso le reduzca la fianza y esa petición tiene que hacerla por medio de su abogado.
Thank you.
Gracias.
Norberto Hernandez.
Got it, Your Honor.
All right. Diego Tavares Fleury.
He's medical, Your Honor.
Defense, I'm going to appoint the public defender to represent you. Did you want to waive his appearance for the purposes of IAs?
Your Honor, can we reset him?
All right, the court will do a 24-hour reset, and he's in medical upon his release from medical, 24 hours upon release from medical. And I believe this is, that's it that I have as far as Spanish interpreter cases.
Your Honor, we have one more, Jimenez Carlos, out of Michigan Dominican.
All right, Jimenez.
Jimenez Carlos, with
Okay.
additional Spanish.
All right, give me one moment. Okay. Got it. Jimenez?
Go ahead.
Ready?
Yes, yes.
All right. All right, sir, could you please state your name?
Por favor, díganos su nombre, señor.
Carlos Alberto Ríos Jiménez.
Repita, por favor.
Carlos Alberto Ríos Jiménez.
Carlos Alberto Ríos Jiménez.
Yes.
What's that this case is?
This is in the misdemeanor domestic violence.
Thank you, Your Honor.
El fiscal ha preguntado qué tipo de caso es este, si un delito menos grave de...
Is there any
Agresión.
victim here on the Carlos Jimenez case?
¿Tenemos alguna víctima aquí presente en el caso de Carlos Jiménez?
Ma'am, please come forward. Do you need an interpreter?
Hacia adelante. ¿Necesita intérprete?
All right, ma'am, could you please raise your right hand to be sworn in?
Derecha para prestar juramento.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth? So help you?
Yes. Gracias. Podemos terminar.
All right, could you please state your name for the record?
Por favor, díganos su nombre para las actas.
Mayrendi Sánchez.
Mayrandi Sánchez.
All right, and defense, would you like to inquire?
¿La defensa quiere hacer alguna pregunta?
Yes, please.
Sí, por favor.
Ma'am, would you like contact with Mr. Jimenez?
Señora, ¿usted quiere tener contacto, comunicación con el señor Jiménez?
Sí.
Yes.
Are you in fear of him?
¿Le tiene temor? No.
And if an incident were to occur, would you call 911?
Si ocurriera un incidente como este en el futuro, ¿usted llamaría al 911? Yes.
No further questions, Your Honor.
¿Ninguna otra pregunta, su señoría?
State any questions?
¿Fiscal tiene alguna pregunta? Sí, su señoría.
Have there been any occurrences of any past violence against you or somebody else?
En el pasado en contra de usted o alguna otra persona. No.
Do you have any children together?
¿Tienen hijos juntos? Yes.
How many?
¿Cuántos? One.
How old is the child?
¿Qué edad tiene el niño?
9 años.
9. He's almost 10.
Okay. And he didn't witness it, did he?
Él no vio el incidente.
No, él estaba despierto, pero estaba jugando Xbox y tenía estaba en el...
He was awake, but he was playing on his Xbox and had the headsets on and was awake in the bedroom.
And does he pay most of the household bills?
Él es el que paga la mayor parte de las cuentas del hogar.
Sí, él es el que está pagando y yo estoy desempleada.
Yes, he's the one that's paying. I am unemployed.
Further questions, Your Honor?
No tengo ninguna otra pregunta, su señoría.
Any additional questions, defense?
¿Alguna otra
No,
pregunta?
Your Honor.
All right, thank you, ma'am. You may have a seat.
Gracias, señora. Se puede sentar.
All right. Defense, Mr. Jimenez does qualify for PTR. Would you wish to be heard with regards to release?
Your Honor, we'd ask for PTR and no hostile contact.
Defensa, el señor califica para el programa de libertad preventiva. ¿Alguna otra cosa? Es elegible para PTR y estamos pidiendo que se le ordene a no tener contacto hostil.
All right, and state?
¿Y el fiscal?
No objection, Your Honor.
No objetamos, su señoría.
All right, the court will grant the defense's request, release the defendant on PTR. The conditions of PTR is that he have no hostile contact with the victim.
Bien, el juez va a dar lugar a la petición del abogado de la defensa. Se le va a permitir libertad bajo el programa de libertad preventiva. No puede tener contacto hostil.
With the victim and that you're not to possess any weapons, firearms, or ammunition.
No puede tener contacto hostil con la víctima, no puede poseer ningún tipo de armas, armas de fuego, municiones,
You're not to consume any alcohol.
no puede consumir bebidas alcohólicas,
And those are all the conditions.
y esas son todas las condiciones.
All right, and are there any, Madam Interpreter, could you make an announcement if there's anyone else who requires the services of an interpreter?
¿Hay alguna otra persona presente que vaya a necesitar los servicios de un intérprete?
All right, thank you, Madam Interpreter.
You're welcome, Your Honor. Have a good afternoon.
You too. So now, for the language line?
Yes.
Okay, so what do? I hit that screen over there?
Now this,
On that keypad?
yes.
Okay. That didn't.
It didn't.
Black.
I'm not. Yeah, well, I don't think she knows.
Oh, the black box.
No. I think maybe you call, and then I hit the black box once you get them on the line. We're gonna take a brief pause while we figure this out.
Yes, Your Honor.
Yeah. All right, let's go ahead and call Marie Bugoli. Is anyone present on this case? Yes. Yes. All right, and do we have our interpreter on the line? Doesn't appear we do. I don't hear the interpreter.
I want to hang up.
Do we have our interpreter on the line?
She said just a minute.
I don't hear the interpreter. All right, just stand by. Sir, just have a seat.
Okay.
All right, ma'am, can you hear us? Madam Interpreter? All right, recalling Marie Bourgeois. All right, and Madam Interpreter, have you been sworn in? All right, do you solemnly swear that you will and truly interpret from Creole to English and English to Creole to the best of your ability? All right. And ma'am, could you please state your name?
Your Honor, we can't hear the interpreter.
Did you hear that?
No.
No, Your Honor, we can't hear the interpreter on our side at all.
All right, just give us one moment to figure out the
Be
technical
able to
issue.
hear, can the interpreter say something else, Judge?
All right, Madam Interpreter, can you repeat that?
Still nothing?
We hear someone talking, that's not the judge.
That's me, I'm the AV technician. I'm trying to work out the issue here.
All right, Madam Interpreter, can you ask the defendant to state her name?
Est-ce qu'on capable de dire non?
Madam Interpreter, could you instruct the defendant to speak louder?
Est-ce qu'on capable de parler plus fort?
Oui, capable parler plus fort.
Yes, I can speak louder.
State your name, please.
Dis non, s'il vous plaît.
Marie-Gona Boujoli.
Marie Bonavi Jolie.
And ma'am,
Marie-Gona Boujoli.
Ma'am, the court has reviewed an affidavit and found probable cause for the charge of aggravated assault.
Madame, tribunal la, yo revize ka, e yo wè gen cause probable pour attaque aggravée ya.
All right, a victim is present here in the courtroom.
Victime nan présent la nan tribunal la.
Sir, do you need an interpreter?
Yeah, I'm not the victim.
Okay, do you need an interpreter though?
A little bit, yeah.
All right, and sir, could you just state your name?
My name is Rodney Radamido.
And what's your relation to Ms. Boujoli?
I'm represent my cousin.
That's your cousin?
My cousin, not Bojoli, the person.
The victim is
the victim,
your
yes.
cousin?
Yes.
All right, sir, just have a seat.
Okay.
Thank you.
Yes.
Your Honor,
Yes,
may I be heard as to probable cause?
you may. Madam Interpreter,
Yes,
can you interpret that, please? Defense wishes to be heard with regards to probable cause.
et sens ta reme pou nou tande li en regard de cause probable la.
Your Honor, there's nothing in the affidavit that states that the victim was in fear that violence was about to take place, and for that reason, there's no probable cause for an aggravated assault.
Juge, pa gen anyen nan affidavit ya ki di ke victime nan ete pran plasi nan accident ki te pase ya. A cause de sa, nou pa wè aucune cause probable.
State response?
Your Honor, it says in the affidavit, would you like the line?
Just tell me what it says.
It says that Alik stated he was able to leave the house. If he felt the need to leave the house, he obviously felt like that he was in danger.
And Your Honor, if I may respond?
Hold on one second. The issue is this is aggravated assault with a deadly weapon. So there may be fear, but he stated the following sentence that he did not see the knife when she was grabbing him.
Yes.
All right. Defense, anything additional?
Your Honor, I'd just like to remind the state that we have to stay within the four corners of the document, so any assumptions would not be proper in this case.
All right. State, anything additional?
Towards the victim's feeling of the threat, no, Your Honor.
All right. So with regards to the deadly weapon, the court finds that there's no PC to the aggravated assault with a deadly weapon. The court finds that there is PC for assault, as there was the stripping of the shirt was intimate contact. It could have put him in fear. With regards to the bond, as to the PC on the assault charge, defense, you wish to be heard?
Your Honor, we would request that the interpreter lets the client know what's going on.
All right, Madam Interpreter.
Sure. Et avec preuve yo montre yo, tribunal la jwen ke pa gen cause et ki montre ki yo te fè an attaque avec yon zam ki kapab la vie. Mais pour attaque la, yo jwen gen cause dans ça.
Your Honor, as to a bond, based on the fact that Your Honor found probable cause for a misdemeanor simple assault, we would ask for a bond to be no more than $500 in this case.
Right.
Stay. Et juge, et comme nous jwen yon probable, et yon cause qui tellement yon attaque, et c'est yon lié, caution, nous avons demandé pour caution pas plus que $500.
You would ask for a $1,000 bond, Your Honor.
Et nous-mêmes, nous avons demandé pour une caution pour $1,000, juge.
All right, the court will set bond in this case at $500. The conditions of bond is that defendant have no contact with the victim.
Et tribunal là, il a mis une caution pour $600. Condition pour caution, ça nous demandé pour défendant pas attaquer victime.
Court will require that she not return to the residence and maintain a separate residence.
Nous demandé pour lui pas arrêter en dans caille là, lui chercher une résidence qui différent, séparé.
Defendant will be allowed to return on one occasion to the residence, accompanied by law enforcement to pick up any personal belongings.
En défendance là, il y a seulement bal permission pour lui retourner dans kay là dans une seule occasion, pour lui aller chercher bagay personnel li et pour lui accompagner par une police.
Defendant is not to possess any weapons, firearms, or ammunition.
Et défendance là, il pas supposé gagner aucune arme, donc aucune arme qui peut tirer ou bien aucune l'autre arme.
All right, thank you, ma'am. All right, thank you, Madam Interpreter.
You're welcome. Thank you for using our services. Your Honor, you have a wonderful day.
Thank you. All right, let's keep going. Those are all of our interpreter cases. Austin Whitmore. All right, sir, could you please state your name?
Austin Whitmore.
All right, Mr. Whitmore, the court finds, based on the affidavit provided, that there's probable cause for the offenses of aggravated assault with a deadly weapon, battery with strangulation, domestic violence, and battery. Defense, did you wish to be heard with regards to release? And the defendant does not qualify for PTR.
Your Honor, it does not look like Mr. Your Honor, may they inquire from PTR why he does not qualify?
Okay. The nature of the offense.
Your Honor, based off of the defendant's lack of history, we would ask for a reasonable bond to be set in this case.
All right, and state?
The state would ask for, as to count one, a bond of $500, count two, $500, and count three, $500 for a total of $1,500.
Well, given the seriousness of count one, I'm going to set bond on count one at $1,000, bond on count two at $500, bond on count three at $500. The court will require that the defendant not have any contact with the victim, that he maintain a separate residence, not return to the residence. He'll be allowed a one-time return with law enforcement to retrieve any personal belongings. And is there any victims here? Okay, so we do have a victim here. Before I step on, I want to hear from the victim, actually. Ma'am, please come forward.
Properly in the chair.
All right, good morning, ma'am. Could you raise your right hand and be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right, and could you state your name?
My name's Jordan Hogan.
All right, and defense, you may inquire.
Ma'am, would you like to have contact with Mr. Whitmore?
Yes, I'm disabled and he's my primary caretaker.
Are you afraid of him?
What was the question?
Are you afraid of him?
Not at all. He was inebriated during the occurrence.
If anything were to occur, would you hesitate calling 911?
Yeah, I would call him immediately.
And would it be a hardship for you to care for yourself since you're disabled if he were incarcerated?
I'm not only unable to work full-time, driving, getting groceries, even showering. He even helps me go to the bathroom on a daily basis. He walks my service animal that is for mobility, so he's a big part of my life.
And what's your relation to him?
He's my fiance.
No further questions, Your Honor.
State?
Could you tell us how often he normally drinks?
Honestly, probably like every 3 to 6 months, but he doesn't usually get drunk.
And do you guys have any children together?
No.
Okay. And is there anybody else in the area who can help you with your day-to-day tasks?
No.
No further questions, Ron.
All right. Thank you, ma'am. You may have a seat. Given the victim's testimony, the court will set bond on count one at $500, bond on count 2 at $100, and bond on count 3 at $100. Defendant is not to have any hostile contact with the victim. He's not to possess or consume any alcohol, any drugs, or any medications without a valid prescription. He's not to possess any weapons, any firearms, or any ammunition. Anything additional from the state?
No, Your Honor.
All right, thank you, sir. All right, Nicole Martinez.
She refused, Your Honor.
I'm sorry?
She refused, Your Honor.
Refused? All right, I'm
Yes.
going to appoint the public defender to represent her. Defense, did you want to waive her appearance for the purposes of initial appearance?
Yes, Your Honor.
All right, the court finds that there is probable cause for the offenses of grand theft, third-degree motor vehicle, possession of fentanyl, and possession of drug paraphernalia. I will appoint the public defender to represent her. Court will leave bond as previously set at $1,000 in count 1, $150 in count 2, and $100 in count 3. She was out on bond on 22 CF 1689. The court will revoke that bond. She was on bond on 22 CT 8450. The court will revoke that bond. And she was on bond in 20 CT 5162. The court will revoke that bond. She was on bond in 22 CF 5284. The court will revoke that bond. So all of those cases, the bonds will be revoked. All right. Amy James.
She refused also, Your Honor.
All right. I will appoint the public defender to represent Ms. James. Defense, did you want to waive her appearance for the purposes of this hearing?
No, Your Honor, can we reset her?
All right, we'll go ahead and reset Ms. James's case. All right, Sean Holton.
Refused, Your Honor.
Okay. I had that he was in the hospital previously. Did the state, I'm going to appoint the public defender. Did you want to waive his appearance for the purposes of IAs?
Yes, Your Honor.
All right. The court having previously found probable cause and having issued a warrant for the arrest of Mr. Holton. Bond was previously set at $1,500 with the conditions that he not possess or consume any unprescribed drugs. The court will leave bond as previously set.
Your Honor, I do apologize. Do you have one more add-on from the felony domestic, Williams Tiffany?
Okay, Tiffany.
Yes, Tiffany Williams.
Okay, let me take a look here.
She's the last felony domestic.
You said misdemeanor domestic?
Felony domestic, Your Honor.
Oh, okay. Okay. Okay, I see. All right. This is Tiffany Williams. Yeah, she's the last of the felony. Tiffany Williams. All right, was she, Miss Williams? Do you have
She's
to?
in a wheelchair. I don't know if you can see her properly.
I can see her, yes, thank you.
Okay.
Ms. Williams, you're charged with 1 count of aggravated battery with a deadly weapon. The court finds that there is probable cause with respect to that offense. Is the victim in that case present? Come up, sir. All right, let's have him sworn in.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth? So help you?
I do.
All right, and sir, could you please state your name?
Frank.
All right, defense, you may inquire.
Sir, would you like to have contact with Miss Tiffany Williams?
I would absolutely like to have contact with Ms. Williams. She is my spouse, and she is suffering from an addiction to fentanyl and heroin. I, as a registered nurse, am trying to assist her through that process, and she needs to be in contact with me for that recovery.
Are you in fear of her?
Not in the least.
And if an incident were to occur, would you call 911?
I would do so if required to, yes.
No further questions, Your Honor.
All right, State.
Yes. Have there any been past events of violence towards you or others?
I have not.
Okay. No further questions, Your Honor.
All right, defense with regards to release.
Your Honor, we'd ask for a $500 bond and no hostile contact.
State.
Your Honor, based on the history, we'd ask for a $1,000 bond and also no hostile contact.
All right. Based on the circumstances, the court will grant the defense's request, set bond at $500. The conditions of bond is that Ms. Williams have no hostile contact with the victim. You're not to possess any weapons, any firearms, or any ammunition. Anything additional from the state?
No, Your Honor.
All right, thank you, sir. You can have a seat. All right, Harold Bray. All right, Mr. Bray, the court has reviewed an affidavit and finds that there's probable cause for the offenses of robbery, sudden snatching, and battery, domestic violence. Are there any victims here on behalf of Mr. Bray? Sir, please come forward. Sir, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth to help you?
And sir, could you state your name?
Harold Bray.
All right, and are you the victim in this case?
My wife is victim.
All right.
She's
All right,
not
sir.
able-
Go ahead.
She's at home. She's not able to come.
All right, I understand that. Defense, did you want to inquire of this witness, although he's not the victim in the case? He indicated that the victim is his wife and that she is physically unable to be present for court.
Did you speak with her in regards to contact?
She doesn't want any contact.
No further questions, Your Honor.
State, any questions? All right, thank you, sir. You may have a seat. All right, defense, did you wish to be heard with regards to release?
Your Honor, we'd ask for a reasonable bond to be set.
All right. And state response?
Your Honor, as to count one, the robbery, we would, the state would be inclined to follow what the court deems necessary. But for count two, battery, we would ask for a $500 bond.
All right, as to count one, the court will set bond at $1,000. Bond on count two will be $500. The conditions of bond is no contact with the victim. You're not to return to the residence. If you need to return to collect any personal belongings, I'll give you an opportunity to return on one occasion, accompanied by law enforcement, to retrieve any personal items. You're not to possess any weapons, any firearms, or any ammunition. With regard, you were out on bond in 21 MM 3571 for the charge of petty theft, defense.
Your Honor, we'd ask for no action to be taken on that case. He's actually out on pretrial diversion. So until pretrial diversion makes a decision on whether he is able to complete the program or he's going to be rejected from the program, there's nothing that's going to happen.
State. With regards to revocation of bond, he's currently in pretrial diversion as to that offense. Is this pretrial diversion level 3 or level 2?
It's misdemeanor pretrial diversion, Your Honor.
Okay.
The state is inclined to follow what the court wants to do with this. The state has no decision at this time.
All right, I'm going to take no action with regards to the underlying offense at this time until the state makes a charging decision.
Thank you, Your Honor.
All right. Melnick Cook. All right, Mr. Cook, the court having reviewed an affidavit finds that there's probable cause for the offense of aggravated battery with a motor vehicle and aggravated assault with a firearm, domestic violence. Are there any victims with regards to Mr. Cook's case present? All right, there's no victims present in the gallery. Defense, did you wish to be heard with regards to release?
Your Honor, we'd ask for a reasonable bond to be set.
All right, state.
Based on the charges, Your Honor, the state would ask for count 1 for the bond to be set at 1,000 and count 2 to be set at 500.
All right. I mean, given the behavior in this case, I mean, this is some pretty serious allegations with regards to his use of the motor vehicle. I'm going to set bond at $5,000 on count 1. The condition of bond is that he not drive unless you have a valid driver's license, that he have no contact with the victim, that he not return to the residence if they were residing together. That's not clear from the affidavit. But if they do reside together, he will maintain a separate residence, and that he not possess any weapons, firearms, or ammunition. With regards to count 2, the court will set bond at $2,500, and those will be the same conditions. As to the case which he was out on bond, 22 CF 4106, if defense wished to be heard with regards to whether the court should revoke bond in that case.
Yes, Your Honor. We'd ask for no action to be taken on that case. The incident did occur on April 12th, and as of now, there have been no, there's been no information filed.
Okay, state.
State asks that you revoke the bond, Your Honor.
I'm going to revoke the bond in that case. Bond will be set at no bond. Jean Dubuisson. All right, 22 CF 6762. Is there a victim present on Mr. Dubuisson's case? Is there anybody here, any victim on Jean Dubuisson? All right, there's no one present in the gallery. Mr. Dubuisson, you have 2 cases. The first case, the court has reviewed the affidavit, finds that there is probable cause with respect to battery, domestic violence by strangulation, battery, domestic violence, and assault, domestic violence. Defense, did you wish to be heard with regards to release?
Your Honor, I'm being told that Mr. Dubuisson has a private, so we'd ask for the PD to be temporarily appointed.
All right, I will provisionally appoint the public defender in this case.
As far as bond, we'd ask for a reasonable bond to be set in this case.
All right, defense? Reasonable bond?
Yes, Your Honor.
All right, as to count 1, the court will set bond at $1,000. As to count 2, the court will set bond at $500. As to count 3, the court will set bond at $500. The court will require that the defendant not have any contact with the victim, that he not possess any weapons, firearms, or ammunition, that he maintain a separate residence. If they were cohabitating, which is not clear, the defendant will have an opportunity on one occasion to return to the residence to retrieve any personal belongings, so long as he's accompanied by law enforcement. There's also a violation of probation. The court will execute that violation of probation. The defendant will be placed on no bond status as to the VOP, and that's in 20 CF 3399. So you can request that the judge who's handling the VOP consider a bond. All right, Almeb Grebiohannes.
Mental health, Your Honor.
All right, defense, did you want to reset this or did you want to waive his appearance?
Your Honor, we'll waive his appearance.
All right, I will appoint the public defender to represent him. With respect to this offense, the charges are aggravated assault with a firearm, resisting an officer without violence, and battery domestic violence.
Your Honor, I believe it's aggravated assault on a law enforcement officer.
Okay, I do see that it's aggravated assault on a law enforcement officer. And defense, did you wish to be heard with regards to release?
Yes, Your Honor, we'd like a reasonable bond in this case. We'd also like the court to take into account that the client has a history of mental health, and it's very clear from the affidavit that there are mental health issues. So we'd just like the court to take that into consideration.
All right, state.
Your Honor, the state would ask for a higher bond based on his history of having a couple of batteries and aggravated assault with a deadly weapon, Your Honor.
As to count one, the court will set bond at $7,500. As to count two, the court will set bond at $100. As to count three, the court will set bond at $100. The conditions of bond will be that the defendant not have any contact with the victim in the domestic violence battery, that he not possess any weapons, firearms, or any ammunition, that he not return to the scene where this incident occurred. And I believe that is all the conditions. All right, St. Phonic Moise.
Yes.
All right, Mr. Moise, the court has reviewed an affidavit which states, which the court finds supports probable cause as to the charge of aggravated battery with a weapon. Is the victim and Mr. Moise's case present? Ma'am, please come forward. All right, ma'am, can you please raise your right hand to be sworn in? They have her sworn in.
Oh, I'm sorry. Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Yes, I do.
All right, ma'am, could you please state your name?
Joanda Lineage.
All right, in defense, you may inquire.
Ma'am, would you like to have contact with Mr. Moise?
Yes.
Are you in fear of him?
No.
And if anything were to happen, would you hesitate to call 911?
No, not at all.
What is your relationship to Mr. Moise?
He's my husband.
And does he help pay the bills in the home?
For right now, he's the only one working, so he's the only one paying all the bills.
So would it be a hardship if you were not able to have contact with you?
Yes, it would be a huge problem.
No further questions, Your Honor.
State.
Do you have children together?
Yes, we have 4, plus my daughter from a previous relationship.
Okay. Has there been any past violence against you?
Not really, no.
Can you explain what you mean by not really?
Back in 2014, yeah, we did have like a little argument when the cops was called, but it was really nothing.
Was anybody arrested then?
Yes, he was. But the case was dropped and everything, like no charge.
Do you have any other family and friends that can help you out?
No.
No further questions, Your Honor. Thank you.
Any other questions from defense?
No, Your Honor.
All right, thank you, ma'am. You may have a seat. All right, defense, with regards to release?
Your Honor, we'd ask for a reasonable bond be set in this case based off of the victim's testimony. She stated that he is the only one that's currently working. He pays the bills, and it would be a hardship for her if they were not able to make contact. For that reason, we'd also ask for no hostile contact.
Okay. Anything additional from the state?
Based on the history I have here on his sheet, Your Honor, he does have another aggravated battery with great bodily harm, and also an aggravated battery on a pregnant woman. Plus, what he testified to. We'd ask for a reasonable bond, but also an elevated reasonable bond based on the history, Your Honor.
All right, the court will set bond in this case at $1,000. The conditions of bond is that he have no hostile contact with the victim, that he not possess any weapons, firearms, or any ammunition. Sir, no hostile contact means you're not to raise your voice, use foul language, or put your hands on the victim unless they give you permission. If you violate those conditions, that will be a violation of your bond, and you'll be back in jail. You understand that, sir?
Yes, sir.
All right, thank you. Jamar Onfroy. All right. Mr. Omfroy, the court has reviewed an affidavit. That affidavit supports probable cause for the offenses of robbery, sudden snatching, tampering with a witness to hinder communication, criminal mischief, grand theft of a dwelling of $100 or more, and battery dating violence. Is any victim present with regards to Mr. Dubos's case? I'm sorry, Mr. Omfroy's case? Mr. Dubose? All right, no one is present in the gallery. Defense, you wish to be heard with regards to release?
Your Honor, we ask for a reasonable bond.
All right, state.
The state would ask for an elevated bond, Your Honor, based on the severity of the charges and also based on the history of battery domestic violence in the past.
The court will leave the bonds as previously set, 2,500 in count 1, 100 on count 2, 100 on count 3, 100 on count 4, and the court will set bond on count 5 at $100. The conditions of bond is no contact with the victim, no return to the residence where the victim resides. If he has any personal belongings there, he will be able to return to the residence on one occasion accompanied by law enforcement to retrieve any personal belongings. The court will also require that he not possess any firearms, ammunition, or any other weapons. Yeah, 2,500, and then count 5, I set it at 100. 100.
Thank you.
100 minus 1, okay. All right. Dennis Pugh. All right, Mr. Pugh, the court finds that there is probable cause with respect to the offenses of false imprisonment, tampering with a witness to hinder communication, and battery domestic violence. Is there any victim present on Mr. Pugh's case? Ma'am, please come forward. Could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Yes, I do.
All right, ma'am, could you please state your name?
Diamond Stevens.
All right, and defense, you may inquire.
Ma'am, would you like to have contact with Mr. Pugh?
Yes. I'm currently working part-time, so he helped me with my bills.
Are you scared of him?
No.
And if an incident were to occur again, would you hesitate to call 911?
No.
What is your relationship to Mr. Pugh?
It's my boyfriend.
And just there, would it be a hard for you if you were not able to have contact with you?
I'm sorry?
Would you have a hard time paying the bills and you were not able to have contact with you?
I don't understand her question.
She said, would you have a hard time paying bills or keeping up with bills?
I'm only working 2 days out of the week.
She indicated you would.
No further questions, Your Honor.
State.
No question, Your Honor.
All right, thank you, ma'am. You may have a seat. Defense with regards to bond.
Your Honor, we'd ask for no hostile contact and a reasonable bond.
Right. State. All right, I'm going to set bond in count 1 at $500, bond on count 2 at $100, bond on count 3 at $100. The conditions of bond is that he not have any hostile contact with the victim, that he not possess any weapons, any firearms, or any ammunition. Mr. Pugh, no hostile contact means you cannot yell, use foul language, or put your hands on the victim without her permission. Do you understand that, sir? All right, thank you, sir. All right, Jeremy Williams.
Jeremy?
All right. Mr. Williams, the court having reviewed an affidavit finds that there's probable cause for the offenses of aggravated assault with a firearm, 2 counts of aggravated assault with a firearm, battery domestic violence with strangulation, and possession of firearm by a convicted felon. Is there any victim present with respect to Jeremy Williams? All right. No one has responded in the gallery. Defense, you wish to be heard with regards to release?
Your Honor, we'd ask for reasonable bonds to be set.
All right, and the state?
Being the severity of the charges, Your Honor, we would ask for an elevated bond.
All right, given the offenses alleged in this case, the court will set bond on count 1 at $5,000, bond on count 2 at $5,000, bond on count 3 at $1,000, and bond on count 4 will remain at $4,000. The conditions of bond is that he not have any contact with the victim whatsoever, that he not possess any weapons, firearms, or any ammunition. And I don't believe that they were cohabitating, so those will be the conditions of bond. Anything additional from the state?
No, Your Honor.
All right. Namira Abushama. All right, Mr. Abushama, the court finds that there is probable cause for the offense of battery domestic violence. Are there any victim present here with regards to Mr. Abushama's case? All right, I see no response. Defense, did you wish to be heard with regards to release?
Your Honor, we'd ask for pre-trial release in this case. We'd also like the court to note that he's also listed as a victim in this instance because he was punched by the alleged victim's boyfriend.
All right. And did the victim and him cohabitate?
No, Your Honor.
All right, anything additional?
No, Your Honor, just that there be a bond of $500.
All right. Because he is eligible for PTR, the court will release him on PTR. The conditions is that he not consume or possess any alcohol, any drugs, or any medication without a valid prescription. I will also require no contact with the victim, and that he not possess any weapons or firearms. All right. Alec Anderson. Alec Anderson, okay. Is there any victim here present on Alec Anderson? Come forward, ma'am. A court having reviewed an affidavit finds that there is probable cause for the offense of battery. Ma'am, could you please raise your right hand and be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Yeah.
All right, ma'am, could you state your name?
Stephanie Castellan.
All right, and defense, did you want to inquire?
Ma'am, would you like to have contact with Mr. Anderson?
I would.
Are you scared of him?
No.
And if an incident were to occur, would you hesitate in calling 911?
No, I wouldn't.
What is your relationship to Mr. Anderson?
Boyfriend?
Do you guys live together?
We do.
Does he help pay the bills?
He does.
No further questions, Your Honor.
State?
You guys have any children together?
We don't.
Can you recall any past occurrences of violence towards you?
No.
And do you also work? How often?
I work Monday.
Okay, so you work full time?
Yeah.
Okay. No further questions, Your Honor.
All right, thank you, ma'am. You may have a seat. All right, defense with regards to release.
Your Honor, we'd ask for no hostile contact and pretrial release.
All right, state, he is eligible for pretrial release.
No objection, Your Honor.
All right, the court will grant the defense's request. Mr. Anderson, you'll be placed on pretrial release. The conditions of pretrial release will be no hostile contact. Mr. Anderson, that means that you're not to use any foul language, yell, or otherwise put your hands on the victim without her permission. Do you understand that?
Speak out loud.
Yes. All right, you're not to possess any weapons, firearms, or ammunition.
No problem.
All right, Shanice Anthony. Hey, is there anyone present on Miss Anthony's case? Forward. All right, Miss Anthony, the court will appoint the public defender. I find that there is probable cause for battery domestic violence based on the affidavit provided. There is a victim present. Sir, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
All right, sir, could you please state your name?
Ryan Anthony.
All right, and defense, did you want to inquire?
Yes. Mr. Anthony, would you like to have contact with Miss Anthony?
Yes. On one condition, that her boyfriend doesn't come back to the house.
Were you able to hear that, defense?
Yes, Your Honor. Do you all live together?
Yes.
All
If an incident were to occur, would you call 911?
Yes.
And what's your relationship with Miss Anthony?
I'm a father.
No further questions.
All right, and state any questions? Hold on a second.
Has there been any past violence by the defendant towards you?
No.
Okay, no further questions.
Sir, was she living with you at the time that this incident occurred? All right, thank you, sir. You can have a seat. All right, defense, with regards to release.
Your Honor, we'd ask for no hostile contact and pretrial release.
All right, she does qualify for pretrial release, state.
No change to pretrial release, Your Honor.
All right, the court will place Ms. Anthony on pretrial release. The conditions is that she have no hostile contact with the victim, that she not possess any weapons, firearms, or ammunition. And no hostile contact means, ma'am, that you're not to use any offensive language, yell, or otherwise put your hands on the victim without their permission. So you understand that if Mr. Anthony has indicated that your boyfriend's not to be at the residence, if he requires that you leave the residence, you refuse to leave, that's a violation of the no hostile contact order. Do you understand that? Ms. Anthony, do you understand that?
Yes, sir.
All right, thank you. LaTanya Bell?
Mental health, Your Honor.
She what now? She refused?
Mental health.
Mental health, Your Honor, mental health.
Mental health.
Yes.
I'm going to appoint the public defender to represent Ms. Bell. Defense, did you want to waive her appearance for the purposes of this hearing?
Yes, Your Honor.
All right, the court having reviewed the affidavit finds that there is a factual basis with regards to the charge of battery domestic violence. Defense, did you wish to be heard with regards to release? She does not qualify for PTR.
Your Honor, we'd ask for a reasonable bond to be set in this case.
All right, and state?
Your Honor, based on lack of history, for this defendant, we would be agreeable to a reasonable bond.
All right, the court will set the bond at $500 in this case. The conditions of bond is that she not have any contact with the victim, that she not return to the residence and maintain a separate residence. She'll be allowed to return to the residence on one occasion accompanied by law enforcement to retrieve any personal belongings and no weapons, firearms, or ammunition. All right, Nazario Flores Maximiliano. Come up, ma'am. All right, I'm going to appoint the public defender to represent you. I find that there is a factual basis for to find probable cause with respect to battery, touch or strike, and simple assault. The victim in the case is present. Ma'am, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you? I do.
All right, in defense, did you want to inquire?
Yes, Your Honor. Ma'am, would you like to have contact?
Yes, I would like to have contact with him.
And are you scared of him?
I'm sorry, repeat?
Are you scared of him?
No.
And if an incident were to occur, would you call 911?
Yes.
What is your relationship?
We've been married 22 years.
Does he help pay the bills?
Yes.
Do you have any children together?
5.
And what are their ages?
From 25 to 12. I'm sorry, to 8. We have the youngest one.
Does he help care for the children?
Yes.
No further questions, Your Honor.
All right, and ma'am, could you just state your name on the record? I don't think we got that.
Jamilet Aisha Marie Flores.
All right, and state any questions for this witness?
Yes. Do you also work full-time?
Yes.
Okay. Do you have any family that are around in the area that can help you? You mean not really? How far are they?
My mom's in Sebring, and she cares for my elderly grandmother.
Okay. Has there been any acts of violence in the past towards you? No? Okay. No further questions, Your Honor.
All right. Thank you, ma'am. All right, with regards to release, defense? He
Your Honor,
doesn't qualify for PTR.
based off of the victim's testimony, the fact that they have children together and he helps pay bills and care for the children, she wants to have contact. we'd ask for no hostile contact and pretrial release.
Right, state?
No objection.
All right, the court will grant the request. Will release Mr. Flores Maximiliano to pretrial release. The conditions of pretrial release will be no hostile contact and that he not possess any weapons, firearms, or ammunition. Mr. Flores Maximiliano, no hostile contact means you're not to have any contact, so no yelling, no screaming, no using foul language, and you're not to put your hands on the victim without her permission. You understand that, sir?
Yes, sir.
All right, thank you. Manny Jones. All right, Mr. Jones, the court finds that there is a factual basis to establish probable cause with respect to the offense of violation of domestic violence injunction. Hold on one moment. This is Judge Calderon. All right, I'll check the warrant in a moment. All right. The court finds that there is probable cause with respect to the offense of violence domestic injunction, or violation of domestic injunction. The court also finds that with regards to 22 MM 3890, there is a warrant where the court previously found probable cause with respect to the charges of battery, domestic violence, criminal mischief, and a previous violation of domestic violence injunction. Ma'am, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Yes, ma'am.
All right, and ma'am, could you say your name?
Tamika Chevelle Green Jones.
All right, and defense, did you want to inquire?
No, Your Honor.
State, did you want to inquire?
I love my husband. You know?
State, do you have any questions?
Yes. What is your relationship with the defendant?
My husband. We've been married for almost 30 years.
Okay. Do you have any children together?
Yes, we have one.
Do you work with your child?
No, I'm on disability.
How old is your child?
My son is 26. He's turned 26. And he's 30. Yeah. He don't want me there. He wants his dad. That's why I'm here to talk, so he can get out. They'll put me out, and then he wants me to get out too. You know, he wants me to get out, so he's back out there. In there. You know, so I don't know about it. I'm living in all my stuff in my car. And I'm stuck in my car for the last couple of days. My body hurt me so bad. You know, he waiting for his dad to be there to me. And he said no me.
Are you afraid of the defendant?
Huh?
Are you afraid of the defendant?
I'm not going to go back. I don't want to be around him no more. You know, he's not good for me. Yeah? I want to go back and take care of my son. My son loves him. He's a good father, but he's not good for me. I will sit in my car before I go back. You hear me?
Do you have a place to stay that's not your car?
No, I don't have nowhere to go. Nowhere. I ain't got no money or anything. You hear me? And I'm hungry. And he don't care. And my son don't care.
No further questions, Ron?
All right, Ms. Jones, is there an active injunction present that prevents him from having contact with you?
Huh?
Is there an active domestic injunction that prevents him from having contact with you?
Yes, yes. I'll go get it taken off so he can go stay with and be with his son. You hear me? Because my son, I don't want my son to suffer or go through anything. My son loves his dad, you know? And he need him, you know?
All right, thank you, ma'am. You may have a seat. Defense, Mr. Jones does qualify for PTR. What would you like to do with regards to release? Please have a seat, ma'am. Go ahead, defense.
Your Honor, I know that there's a domestic injunction in place, so there's nothing this court can do as far as no hostile contact. So for that reason, based off of the victim's testimony, it is pretty clear that she wants contact despite the injunction. So I know that no contact needs to be in place, but we'd ask for him to be released on PCR based off of the testimony today.
State.
Based on the testimony, Your Honor, we would ask for a bond. Also, we'd ask for no contact as opposed to no hostile contact.
All right, the defendant qualifies for PTR. The court will release him on PTR. The conditions of PTR with regards to the violation of domestic injunction is that he not have any contact with the victim. that he not possess any weapons, firearms, or ammunition. With regards to the battery domestic violence, he will be released on PTR. The conditions will be that he not have any contact with the victim, that he not possess any weapons, firearms, or ammunition. With regards to count 2, will be released on PTR with the same conditions. And as to count 3, he'll be released on PTR with regards, and it will be on the same conditions as counts 1 and 2.
1, 2, and 3, Judge?
Ma'am, please exit the courtroom. Yes?
I have 3 counts, but that's a violation of domestic.
Yeah, because I had that separately. I feel like it's 2.
Why they have 3? Can I?
Yeah, there's a third one here.
Okay.
Yeah, PTR as well.
Thank you, Judge.
PTR same conditions as 1 and 2. All right. Cassandra McLean. All right. And the court will note that there are no victims present in the gallery at this time. Ms. McLean, the court finds that there is sufficient probable cause with respect to the offense of battery, domestic violence, and as to both counts, the court finds that there is probable cause. Defense, did you wish to be heard with regards to release? She's eligible for PTR.
Your Honor, we'd ask for PTR.
All right, and state.
No objection, Your Honor.
All right, the court will release the Ms. McLean on PTR. The conditions of PTR will be no contact with the victim. And were they residing together?
Yes, Your Honor.
All right, the defendant will be required to maintain a separate resident, not return to the resident, but I will allow a one-time return accompanied by law enforcement to retrieve any personal belongings. You are not to possess any weapons, firearms, or ammunition.
Which one is that case?
This is 22 MM 3957. All right, Janizette Ortega.
She's mental health, Your Honor.
I'm going to appoint the public defender to represent her. Defense, did you want to waive her appearance or reset?
We can waive, Your Honor.
All right. Ms. Ortega does not qualify for PTR. The court finds that there is probable cause with regards to the offense of battery, domestic violence. Did you wish to be heard with regards to release?
Yes, Your Honor.
All right, go ahead.
Your Honor, we'd ask for a bond of no more than $250 in this case. It's clear that there are mental health issues. And the alleged victim in the case stated that the client had just recently been Baker acted and bringing her home from being Baker acted. So for that reason, we'd ask for that amount of bond.
All right, state.
State has no objection to a $250 bond, Your Honor.
All right, the court will set bond at $250. The conditions of bond is that she not have no contact with the victim, not return to the residence, and no weapons, firearms, or ammunition. All right, Kamar Slavery. All right. The court finds that there is probable cause with respect to the offense of battery domestic violence. Again, there's no victim present in the gallery. Defense, did you wish to be heard with regards to release? And he is not eligible for PTR.
Your Honor, we'd ask for a reasonable bond to be set in this case.
All right. And where was the victim and he cohabitating?
Were you guys living together? Were you living together? Yeah. Yes.
All right. Defense?
Yes, Your Honor.
Amount for bond requested?
Your Honor, we'd ask for a reasonable bond.
Okay. State?
State would ask for a $500 bond, Your Honor.
All right. The court will set bond at $500. The conditions of bond are no contact with the victim, maintain separate residence, no return to the residence. I will grant a one-time return accompanied by law enforcement to retrieve any personal belongings. You're not to possess any weapons, firearms, or ammunition. All right, Miguel Valverde. All right. Mr. Valverde, the court having previously found there was probable cause for the offense of stalking, domestic violence. The court would note that the defendant is not eligible for PTR. Defense with regards to release.
Your Honor, we'd ask for a reasonable bond.
All right, and state response.
The state would ask for a $1,000 bond, Your Honor.
All right, the court will set bond at $1,000. The conditions of bond is no contact with the victim, and you're not to possess any weapons, any firearms, or any ammunition. And that's no contact, direct or indirect contact.
Yes, sir.
All right, thank you. Julio Acosta Diaz. All right. Mr. Acosta Diaz, I'm going to appoint the public defender to represent you. You have 3 cases that we'll be addressing today. The first case, the court finds that there is a factual basis for.
Your Honor.
Go ahead.
May I be heard on probable cause for the carjacking and the grand theft motor vehicle?
Yeah, I'm going to do the possession case and the out-of-county warrant cases, and then I'll do that one last, okay? So as to 22 CF 6787, the court finds that there is probable cause as to possession of fentanyl, possession of cocaine, possession of cannabis less than 20, and possession of drug paraphernalia. Defense, did you wish to be heard with regards to release as to those charges?
Your Honor, we'd ask for reasonable bonds in these charges, and as for the possession of cannabis less than 20 grams, we'd ask for ROR because the state of Florida is not prosecuting marijuana cases less than 20 grams.
All right, state.
No objection.
All right, so as to that case, the court will leave bond as previously said on counts 1 and 2. I will ROR the defendant on count 3 and leave bond as previously said in count 4 at $500. The conditions of bond is that he not possess any drugs or any medications unless he has a valid prescription.
And Your
With
Honor,
regards,
I'm sorry, can you remind me the bonds for counts 1 and 2?
1,000, ROR, and 500.
Thank you.
You're welcome. All right, with regards to 22 CF 445, the defendant has warrants out of Osceola County. The court issued a warrant for his arrest at bond at no bonds in those 3 counts. The court, or 2 counts, the court will leave, no, it's 3 counts. The court will leave those bonds as previously set in the warrant. All right, in 22 CF 6785, and defense, you wanted to be heard with regards to probable causes to count 1?
For the carjacking and for the grand theft motor vehicle, Your Honor.
All right, go ahead.
Your Honor, the defense takes the position that there's no probable cause for either of these charges. The owner of the vehicle was not able to pick client up out of a lineup. So although the report may state that he matches the description, that does not give rise to the level of probable cause, which is necessary to hold him on these charges, Your Honor.
All right. So the question as to identity.
Your Honor, there's nothing to state that he was the person that stole this vehicle.
All right, state response.
State would ask for a 24-hour reset so we can address this issue.
All right, the court will set bond on count 2 and 3, leave it as previously set at $1,000. The court will reset this case for a finding for the court to state to provide additional information with regards to PC for the carjacking on count 1. So we'll reset this one case. With regards to the 22 CF 6786, driving with a suspended license, a third or subsequent violation, the court finds that there's probable cause for that offense. Defense, did you wish to be heard with regards to release?
Your Honor, I would ask for a reasonable bond.
State.
No objection to a reasonable bond, Your Honor.
All right, the court will reduce that bond to $2,500. Conditions is that he not drive without a valid driver's license, that he not possess any weapons, firearms, or ammunition.
Thank you, Your Honor.
Thank you. Russell Detweiler?
Mental health, Your Honor.
I'm sorry?
Mental health.
Mental health. I'm going to appoint the public defender to represent him. Did you want to address these cases by waiving his appearance?
Yes, Your Honor.
Okay. All right. The court finds there's 2 cases. The first case, the court finds there's probable cause for possession of a controlled substance without a valid prescription and possession of drug paraphernalia. Defense, did you wish to be heard with regards to release? He does not qualify for PTR.
Your Honor, we'd ask for a $1,000 bond on the possession of controlled substance and a $250 bond on the possession of drug paraphernalia.
State? All right, the court will set bond at $1,000 on count 1, $250 on count 2. The conditions of bond is that he not possess or consume any drugs or any medications unless you have a valid prescription. As to 22 CF 2357, the court finds there's probable cause for the offense of driving while license suspended as a habitual traffic offender. Defense, did you wish to be heard with regards to bond?
Your Honor, we'd ask for a $250 bond.
State?
The state would ask that the bond remain at $500, Your Honor.
All right, the court will leave the bond as previously set at $500, the conditions that he not drive unless he possess a valid driver's license. All right, Sergio Fernandez.
He bonded, Your Honor.
All right. Willie Heath. All right, Mr. Heath, the court finds that there is probable cause for the offense of aggravated assault with a weapon, criminal mischief, and a phrase. Defense, do you wish to be heard with regards to release? He is not eligible for PTR.
Your Honor, this is Mr. Heath.
Yes.
I'm
sorry.
Okay.
I have Hart. I was looking at the wrong sheet. It's Mr. Hart. I apologize.
So, Your Honor, I don't have a heart.
Camille Hart.
Booking number, you may have bonded.
This is the booking number.
Yes, I don't have
Hart. Booking number, I have the booking number. Is that what you're asking for? I'm sorry.
It's not.
Booking number on Hart is 22013460.
Maybe Trayvon Russ.
No, it's Camille Hart.
13430, did you say?
22013460.
Bonded.
Bonded?
Yes.
All right, Mr. Hart bonded. Mr. Heath, I do find that there's probable cause for the offense of possession of cocaine. Defense, he does not qualify for PTR. Bond was previously set at $1,000. Did you want to be heard?
Your Honor, we'd ask the bond to stay.
All right. State.
Yes, it remain at 1,000, Your Honor.
All right. The court will leave the bond as previously said. The conditions will be that he not possess or consume any drugs or any medications unless he has a valid prescription. Douglas Kennan. All right, Mr. Kennan, the court having reviewed the affidavit finds that there's probable cause for possession of MDMA, possession of cannabis with intent to sell or deliver, and possession of drug paraphernalia. State, did you wish to be heard with regards to bond?
Yes, Your Honor. The state asks that all bonds remain as set.
Defense?
Your Honor, we'd ask for a reasonable bond.
All right, as to count one, the court will set bond at $7,500. Bond on count two will remain at $150. Bond on count three will remain at $100.
I'm sorry, Your Honor, could you repeat that?
Count one, $7,500. Count two will remain at $150. Count three will remain at $100. As to the conditions, he is not to possess or consume any drugs or any medications unless he possesses a valid prescription. And he was out on bond in 22 CF 5669 for possession of MDMA and possession of cannabis. Defense, did you wish to be heard with regards to whether the court should revoke the bonds in that case?
Your Honor, we'd ask for the bonds not to be revoked, that those charges have not been filed on.
All right, state.
State asks that the bonds be revoked.
All right, given that it is the same offense which he was rearrested on, the court will revoke the bond, set bond at no bond in both counts. The defense can file motions before the presiding judge for him to or her to reconsider the setting bond in these cases. All right, Vince Rogers. All right, Mr. Rogers, the court finds that there is a factual basis for probable cause as to aggravated assault with a firearm, trafficking cocaine, possession of a firearm by a convicted felon, and possession of firearm with an altered serial number. Defense, did you wish to be heard with regards to release?
Your Honor, we'd ask for a reasonable bond to be set in this case.
State?
The state asks that the bonds remain as set, and also for count 3, possession of a firearm for a convicted felon, the bond be set at $10,000.
All right, the court will set bond on count 1 as previously said at $2,500. Bond on count 2 will remain as previously said at $50,000. Bond on count 3 will be set at $2,500, and bond on count 4 will remain as previously set at $500. The conditions of bond is that he not possess any drugs or any medications unless you have a valid prescription, and that he not possess any firearms, ammunition, or any weapons. All right, Ahad Smith. All right, Mr. Smith, the court finds that there is probable cause for the charge of carrying concealed firearm. Defense, with regards to release, he's eligible for PTR. What would you request the court do in this case?
Your Honor, we'd ask for PTR.
All right, State?
Your Honor, did you say he qualified for PTR?
He does.
No objection to PTR, Your Honor.
All right, the court will release Mr. Smith on PTR. The conditions of PTR is that he not possess any weapons, firearms, or ammunition. Carlos Vargas?
You refuse, Your Honor.
All right, I'm going to appoint the public defender to represent him. Do you want to waive his appearance or reset this case?
We'll waive it, Your Honor.
All right. The court finds that there is probable cause to establish delivering a controlled substance within 1,000 feet of a specified area. And count 2, use of a communication device. With regards to bond, he does not qualify for PTR. Defense, did you wish to be heard?
Your Honor, we'd ask for reasonable bonds to be set.
All right, State.
State asks that the bonds remain as set.
All right, the court will leave the bonds as previously set. Count 1 will remain at 5,000. Count 2 will remain at 150. The court will require that he not possess or consume any drugs or any medications unless you have a valid prescription. 22 CF 234. The court finds that there is a probable cause to establish delivering a controlled substance within 1,000 feet of the specified area and unlawful use of a two-way communication device. Defense, did you wish to be heard with regards to the bonds were previously set at 2,000 and 250? Do you want to be heard with regards to release?
Your Honor, we'd ask for the bonds to remain.
All right, State?
No objection.
All right, the bonds will remain as previously said. The conditions will be that he not possess or consume any drugs or any medications unless you have a valid prescription, no weapons or firearms or ammunition. All right, Humberto Vasquez?
Yes, Your Honor.
Mr. Vasquez, I find that there is a factual basis for the charges
Your
of
Honor.
burglary. Yes?
May I be heard on probable cause?
Sure.
Your Honor, as to count 1, burglary of an occupied structure, according to the affidavit, it doesn't appear that he ever entered the structure.
Okay. All right, and defense, it's attempted burglary. Wait, is it attempted or burglary?
I have
Oh,
it
it's
as
burglary. Okay. State response?
From the affidavit, it says that he was seen using 20-inch pliers to cut through the gate.
Your Honor, if I may?
You may.
If I remember correctly, it said that he was attempting to cut the gate.
Yeah, I think on line 3 it says using. And then later on they say that they saw him trying to cut through the gate on camera.
And Your Honor, I apologize, I don't have it in front of me because I don't have internet. But if I remember correctly, it states that he was seen on camera attempting to cut the gate, and then they went to confront him about it, and that's when it ceased.
All right. State, do you need more time would you like to try to present or get clarification or present additional evidence with regards to whether or not he actually was able to cut through the gate?
Yes, Your Honor, we'd after a 24-hour reset.
All right, so the court will grant that request. As to the count 1, the court will reset that for additional evidence to be provided as to PC. On counts 2 and 3, the bonds will remain as previously set. And so we'll make that determination based on the court finding PC as to counts 2 and 3. He was out on bond on attempted burglary of a conveyance and possession of burglary tools. Defense, did you wish to be heard on whether bond should be revoked in 22 CF 5412?
Your Honor, we would ask that no action be taken and hasn't been filed on. We'd also ask for the decision on whether to revoke or not be rolled with the PC challenge for count 1.
All right, and state response? All right, I'm going to go ahead and revoke the bond on this case based on the finding of PCS to counts 2 and 3. Those were the charges which, one of those charges he was out on bond for. So the court will revoke the bonds on that basis. But the defense will have an opportunity to argue probable cause with respect to count 1 tomorrow. Yeah, I'm going to stay the bond until a PC can be determined. All right, John Nettles.
He refused, Your Honor.
All right, I'm going to appoint the public defender to represent him. Defense, did you want to waive his appearance for this hearing, or did you want to
Yes.
reset?
We can waive it, Your Honor.
All right. Defense having waived his appearance, the court finds that there is probable cause with respect to the offense of battery. He's not eligible for PTR. Bond was previously set at $5,000. Did you wish to be heard with regards to bond?
Your Honor, we'd ask for a reasonable bond being set.
For what?
A reasonable bond.
State?
The state would ask for the bond to remain as set.
All right. And given that the court the judge had previously signed the warrant setting bond at $5,000, the court will leave the bond as previously set. The conditions that he not have any contact with the victim, that not return, no contact, and no weapons, firearms, or ammunition. All right. Preston Carroll. All right, Mr. Carroll, the court finds that there is a factual basis with respect to 22 CT 3207 and 22 CT 3206 for the charges of possession of a canceled or revoked driver's license and driving while license suspended. Defense, did you wish to be heard with regards to release? And I would just note that he is not eligible for PTR.
We ask for a $250 bond on count 1 and a $100 bond on count 2.
All right, state?
No objection, Your Honor.
All right. And that was 250, and I'm sorry, what were the amounts that the defense requested?
250 for count 1, 100 for count 2.
Court will set bond at 250 on count 1 and 100 on count 2. Defendant is to not drive unless he possesses a valid driver's license. In 22 MN 3945, court finds that there is factual basis for the charge of making a false report to law enforcement. Defense, did you wish to be heard in regards to that offense?
Your Honor, we'd ask for a $250 bond.
State?
Should ask for a $500 bond, Your Honor.
Right, the court will leave the bond as previously set at $500 as to that offense. As to 2000, I guess he was on probation in another case out of Lake County for a suspended driver's license. And was he on probation on 1 count or 2? All right, he was out on probation on 2 cases. Defense, did you wish to be heard with regards to the VOP? Hence?
Lake County too for that.
I'm sorry.
Both out of-
Pulled out of Lake County for those violations.
Yeah, so he's got 2 violations of probation out of Lake County.
Yes, Your Honor.
The court will, based on those warrants, the court will leave those bonds set at no bond. Defendant will remain in custody as to those charges. All right, Stevenson Polonice. All right. Ms. Polonice, a warrant for your arrest was issued based on your failure to appear at arraignment. Bond was set at $500. Does not qualify for PTR. Defense, did you wish to be heard with regards to release?
Your Honor, we'd ask the bond to stay as it is.
All right, state.
Objection.
All right, the bond will remain as previously said. The defendant is, the condition will be that defendant is not to drive unless he possesses a valid driver's license. All right, Jacob Barnes.
Your
I'm
Honor,
sorry.
can we take a 5-minute break?
Hold on, I missed one before we get to that next one. Cor Viasis.
Hey, PTR, Your Honor.
He already PTR?
Yes.
All right. All right, and you wanted a 5-minute break?
Yes, Your Honor.
All right, we'll take a brief recess.
We're ready, Your Honor.
All right, let's go ahead and continue. Jacob Barnes. All right, Mr. Barnes, the court finds that there is probable cause with respect to the offense of trespassing in a structure of conveyance. Defense, did you want to try to resolve this case?
Your Honor, the state has extended an offer of withhold of adjudication, credit for time served, court costs, and no return. We'd like to take that offer at this time.
All right. How much credit does he have?
1, Your Honor.
All right. Mr. Barnes, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
All right, just state your name for the record.
Take your name.
Jacob Barnes.
All right, and Mr. Barnes, are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
How far did you go in school?
11.
And do you read and write in English?
Yes.
And did you read and understand the constitutional rights contained in your plea form?
Yes.
Did you go over that plea form with your attorney?
Yes, Your Honor.
And did she answer any questions that you may have had?
No, sir.
Do you have questions?
No, sir.
Yes.
Did she answer all of your questions?
Oh, yes.
Do you understand that by entering this plea, you're giving up all the constitutional rights contained in your plea form?
Yes, sir.
And did you sign that plea form?
Yes, sir.
As to the charge of trespassing in a structure of conveyance, how do you plead?
No contest?
And do you understand that the maximum sentence for this offense is up to 60 days in jail?
Yes, sir.
Knowing that, are you entering your plea freely and voluntarily?
Yes, sir.
Do you understand that by entering this plea, there will be no trial and that I will impose sentence based upon the plea agreement?
Yes, sir.
All right. With regards to sentencing, as to count 1, the court will withhold adjudication, sentence you to 1 day in the Orange County Jail with credit for 1 day time served, but will impose court costs, and you are not to return to the scene where this incident occurred. Can you afford to make any payments towards your court cost fees and fines?
Yes, sir.
All right, I'm gonna, do you want 60 days to pay all the court cost fees and fines?
Yes, please, Your Honor.
All right, I'm gonna require that you pay all court cost fees and fines within 60 days. I also want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you, sir. Jamar Jarvis. Good. Jarvis? Okay. Okay. All right, Mr. Jarvis, the court finds that there is probable cause for the offense of trespass on property after warning and resisting an officer without violence. Defense, did you want to try to resolve this case?
Your Honor, the state has extended an offer as to count 1, an adjudication of guilt, credit for time served and court costs, and as to count 2, a withhold of adjudication and court costs. We'd like to take that offer at this time.
All right, and how much credit does he have? 2 days? Okay. All right, and sir, can you please raise your right hand to be sworn in? Can we have him sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, sir, could you please state your full name, put your hand down?
Jamar Rashad Jarvis Jr.
All right, and Mr. Jarvis, it's my understanding you want to accept the state's plea offer, is that correct?
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No, I'm not.
Are you suffering from any mental illness or emotional disturbance at this time?
No, sir.
How far did you go in school?
9th.
Do you read and write in English?
Yes.
Did you read and understand the constitutional rights contained in your plea form?
Yes.
And did you go over that plea form with your lawyer?
Yes.
And did she answer all of your questions?
Yes.
You understand that by entering this plea, you're giving up all the constitutional rights contained in your plea form?
Yes. And I ask you another question, you know? I was talking about the officer about my walk.
All right, as to count one to the charge of, I'm sorry, did you sign your form? Did you sign the last page of the plea form?
Yes.
As to count one, trespass on property, after warning, how do you plea?
No contact.
As to count two, resisting without violence, how do you plea?
No contact.
And are you entering those pleas freely and voluntarily?
No, no one forced me.
All right, are you entering your pleas freely and voluntarily?
Yes.
Do you understand that by entering this plea that there will be no trial and that I will impose the sentence that was announced?
Yes.
All right, as to count one, I will adjudicate you guilty. I will sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs. As to count two, I will withhold adjudication, sentence you to 2 days in the Orange County Jail with 2 days' credit time served. That will run concurrent to count one. I will impose court costs. Sir, can you afford to make any payments towards your court cost fees and fines?
No.
All right. I'm going to reduce all of your fees and fines to a civil judgment. All right, I want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you, sir. All right, 2022 MM 3955, State versus William Johnson. All right, Mr. Johnson, I find that there is probable cause with respect to the offenses of petty theft as to counts 1 and 2. Defense, did you want to try to resolve this case?
Your Honor, the state did not give an offer for this case. I would assume it's because it's a petty theft.
All right, with regards to release, bonds were set at $250 on each charge. He does not qualify for PTR.
Your Honor, we'd ask for $100 bonds on each charge.
State?
The state would ask that the bonds remain as Your Honor has just stated at $250 each.
The court will leave the bonds as previously said. The conditions will be that he not return to the scene where this incident occurred, that he have no contact with the victim, that he not possess any weapons or any firearms or any ammunition. All right, Christian Legra.
Bond, Your Honor.
Ahmed Phoenix. All right, Mr. Phoenix, the court finds that there is probable cause for the offenses of disturbing the peace at a lodge and count 2, resisting an officer without violence. Defense, did you want to try to resolve this case?
Your Honor, the state has extended an offer as to count 1, it's a withhold of adjudication, credit for time served, and court costs. As to count 2, it's an adjudication and credit for time served. We'd like to take that plea at this time.
All right, how much credit does he have? Okay. All right, and sir, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth? So help you?
Yes.
All right, sir, you can put your hand down. Could you state your name? All right, and Mr. Phoenix, it's my understanding you want to enter a plea today. Is that correct?
Right.
Are you under the influence of any drugs, alcohol, or medication at this time?
No, sure.
Are you suffering from any mental illness or emotional disturbance?
No.
How far did you go in school?
9th grade.
And do you read and write in English?
Yes.
Did you read and understand the constitutional rights in your plea form?
Yes.
Did you go over that plea form with your lawyer?
Yes.
And did they answer any questions?
Hello. Yes.
Do you understand that by entering this plea that you're giving up the constitutional rights contained in your plea form? And did you sign that plea form? As to count 1, disturbing the peace, how do you plea?
No contest.
As to count 2, resisting an officer without violence, how do you plea?
No contest.
And are you entering those pleas freely and voluntarily?
Correct.
And do you understand that by entering this plea that there will be no trial and that I will impose the sentence that was announced?
Correct.
All right. As to count 1, I will withhold adjudication. I will sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs. As to count 2, I will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. That will run concurrent to count 1. Sir, can you afford to make payments towards your court costs, fees, and fines?
Calls.
Can you afford to make payments?
What's the total, Your Honor?
What's the total?
It's $273, Judge.
$273.
Yeah, correct.
You want 60 days to pay all that?
Your Honor, if we can get 60 days.
All right. The court will give you 60 days to pay all your court costs, fees, and fines. I also want to advise you that you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you. Joseph Rooney. All right, Mr. Rooney, the court finds that there is probable cause for the offense of trespassing. Defense, did you want to try to resolve this case today?
Your Honor, the state has extended an offer of an adjudication of guilt, credit for time served, court costs, and no return. We'd like to take that at this time.
How much credit does he have? All right, sir, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, sir, could you please state your name?
Joseph William Rooney, second.
All right, and Mr. Rooney, it's my understanding you want to enter a plea, is that correct?
Yes.
Are you under the influence of any drugs, alcohol, or medication at this time?
No.
Are you suffering from any mental illness or emotional disturbance?
No.
How far did you go in school?
Trade.
And do you read and write in English?
Correct.
And did you read and understand the constitutional rights contained in your plea form?
Yes.
Did you go over that plea form with your attorney?
Yes.
And did she answer all of your questions?
Yes.
You understand that by entering this plea that you're giving up the constitutional rights contained in your plea form?
Correct.
All right, as to count 1 trespass, how do you plead?
No contest.
All right, and are you entering that plea freely and voluntarily?
Yes.
Do you understand that by entering this plea that there will be no trial and that I will impose the sentence that was announced earlier?
Yes.
All right. As to count 1, the court will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. That will impose court costs and a no return to the scene order. Sir, can you afford to pay your court costs, fees, and fines?
Not right now.
If I give you 60 days, would you be able to pay them in 60 days?
If I can set up some type of arrangement, I guess,
Your Honor,
Yes.
we'd ask for the fees to be reduced to a civil judgment.
All right. Given the client's inability to pay, the court will reduce the court costs and fees and fines to a civil judgment.
All right, man.
All right. Trevon Russ.
Hey, John.
All right. And Mr. Russ, I do find that there is probable cause for the offense of trespass on property after warning. The defense, Mr. Russ, was out on bond as to a burglary of obstruction, a grand theft. Before we consider resolving this case, did you wish to be heard with regards to revocation of the bond in that case?
Your Honor, we'd ask for a bond not to be revoked on that case. These two are not related. Additionally, the state has extended a credit time served offer for this case, in which Mr. Russ has stated that he wants to take it. So we'd ask that no action be taken on the case he's out on bond for.
All right, defense.
Yes, Your Honor?
So you want him to enter the plea on this one and not revoke the bond on the new case, correct?
Yes, Your Honor, but we'd ask for the court's decision on whether you were going to revoke bond or not before we resolve the case.
Okay, I just wanted to make sure. State, what's your position on the revocation?
They'd ask that the bond be revoked, Your Honor.
All right, given the allegations in this case, it doesn't seem that this was an attempted burglary of any sort. It appears that the defendant in this case was sleeping in a location where he had previously been trespassed. So I'm not going to revoke the bond as to the burglary count. Defense, did you want to move forward with the plea?
Yes, Your Honor, the state's offer in this case is a withhold of adjudication, credit for time served, court costs, and no return to the scene.
All right, and sir, could you please raise your right hand to be sworn in? How much credits?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
All right, sir, could you please state your full name and date of birth?
Trayvon Devontae Russ, July 21st, 2002.
All right, and Mr. Russ, it's my understanding you want to enter a plea today to resolve this case, is that correct?
Yes, sir. Yes, Your Honor.
Are you under the influence of any drugs, alcohol, or medication at this time?
No, Your Honor.
Are you suffering from any mental illness or emotional disturbance?
Oh, no, Your Honor.
How far did you go in school?
GED.
Do you read and write in English?
Yes, Your Honor.
And did you read and understand the constitutional rights contained in your plea form?
Yes, Your Honor.
And did you go over that plea form with your attorney?
Yes, Your Honor.
And did she answer all of your questions? Did she answer all of your questions?
Yes, Your Honor.
All right. How do you plead to the charge of trespass on property after warning, a first-degree misdemeanor?
No contact.
And did you sign your plea form?
Yes, Your Honor.
All right. And are you entering your plea freely and voluntarily?
Yes, Your Honor.
All right. All right, we'll proceed with sentencing. As to count one, the court will withhold adjudication, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and require that you not return to the scene where this incident occurred. Mr. Russ, can you afford to make any payments towards your court costs, fees, and fines?
Yes, Your Honor.
You can make payments?
Try to make payments, but no, probably not.
Okay.
Your Honor, we'd ask for a civil judgment.
All right, I'm going to reduce your court costs, fees, and fines to a civil judgment. All right, Mr. Russ, I also want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing. It must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you, sir. Luis Santiago? Yes, no action.
He refused, Your Honor.
All right, I'm going to appoint the public defender to represent him. Defense, did you want to reset this, or did you want to address it today and waive his appearance?
Can we reset, Your Honor?
All right, we'll reset Mr. Santiago for tomorrow. All right, Ronnie Thomas?
He also refused, Your Honor.
All right, I'm going to appoint the public defender to represent him. Defense, you want to reset this?
Your Honor, we'll waive his appearance.
All right, defense having waived his appearance, the court finds that there is a factual basis for the charge of battery. The court finds probable cause with respect to that count. The bond was previously set at $500. Defense, did you wish to be heard with regards to release?
Your Honor, we'd ask for the bond to remain.
State?
Objection.
All right, the court will leave the bond as previously set. The conditions of bond is no contact with the victim and need not possess any weapons, firearms, or ammunition. All right, DeMarco Wilson? All right, Mr. Wilson, the court finds that there's probable cause for the offense of trespass on property after warning. Defense, were you wanting to resolve this case today?
Yes, Your Honor, the state has extended an offer of an adjudication of guilt, credit for time served, court costs, and no return. We'd like to take that at this time.
All right, and 2 days? All right, can we, sir, can you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony shall be the truth, the whole truth, and nothing but the truth? So help you. Thank you.
All right, sir, you can put your hand down. Sir, could you please state your name for the record?
Mark Jamal Wilson.
I'm sorry, what is it? I can hear you.
Mark Jamal Wilson.
Thank you, sir. All All right, and Mr., you said your last name is Lewis or Wilson?
Wilson.
Wilson, okay. All right, Mr. Wilson, you've heard what's been announced here today. Do you want to, it's my understanding you want to accept the plea offer, is that correct? All right. And are you under the influence of any drugs, alcohol, or medication at this time? Are you suffering from any mental illness at this time? How far did you go in school? And do you read and write in English? And did you read and understand the constitutional rights contained in your plea form? And did you go over that plea form with your attorney? And did she answer all of your questions? All right, do you understand that by entering this plea that you're giving up the constitutional rights contained in your plea form? And did you sign that plea form? As to count 1 trespass on property after warning of first-degree misdemeanor, how do you plea? And are you entering that plea because you believe it is in your best interest? And knowing, and do you understand that the maximum sentence for this offense is up to 1 year in jail? And do you understand that by entering this plea that there will be no trial and that I will impose sentence based upon the plea agreement? All right. As to count 1, I will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and require you not to return to the scene where this incident occurred. Sir, can you afford to make any payments towards your court costs, fees, and fines?
You'd like to know the total, Your Honor?
I'm sorry, I couldn't hear you.
The total?
What's the total?
$273.
$273.
Your Honor, we'd ask for a civil judgment.
All right, the court will reduce all court costs, fees, and fines to a civil judgment. All right, sir, I want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you. All right, Daniel Eller.
Mental health, Your Honor.
All right, I'm going to appoint the public defender to represent him. Defense, did you want to waive his appearance for the purposes of this hearing?
Yes, Your Honor.
All right, Mr. Eller has 2 out-of-county warrants. Those warrants are out of Marion County. The bond in those warrants is set at no bond and will remain as previously set. All right, Brandon Palmer.
Hospital, Your Honor.
All right, defense, did you want to reset this or did you want to waive his appearance?
We'll waive his appearance, Your Honor.
All right, the court will appoint the public defender. The public defender has waived the defendant's appearance. This is an out-of-county warrant for a failure to appear. Bond was set at $1,000 on that warrant and will remain as previously set. There's another case out of the same county, out of Seminole. There was also a failure to appear in that case. Court set bond at $1,000. The bond will remain as previously set. I have 2. Yeah, but it may be just a duplicate. It looks like it's a duplicate.
Palmer?
Yeah, it might be a duplicate. Just look at this. It looks like the same case number.
Yes, it is.
All right, so that's a duplicate. It's just one warrant, and the court will leave the bond that's previously set at $1,000. All right, Shelley Simpson. All right, Ms. Simpson, you have a warrant for a failure to appear out of, it's like Volusia County. The bond in that warrant was set at 0. This is on a no valid driver's license. The court will leave the bond as previously set and appoint the public defender provisionally to represent the victim. All right, Ms. Simpson, you can request that the judge in Volusia consider setting a bond in this case. All right, thank you, ma'am. All right, Tommy Mills. Mr. Mills, I will appoint the public defender to represent you. You've been charged with the offense of trespass on property after warning. Offense, were you trying to resolve this case today?
Yes, Your Honor, we would like to. This is a reset from yesterday, so I don't have an offer from the state or the court. Would either be willing to extend an offer at this time?
All right, state, this was a reset. This was a trespass on a property after warning.
Okay. Okay, the offer in this case will be a withhold court costs, credit time served, and no return to scene.
Okay, thank you. All right, does he want to accept that offer?
We'll take that offer. I apologize, Your Honor.
Okay. All right, sir, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
All right, sir, could you please state your full name?
Tommy Lee Mills.
All right, and Mr. Mills, it's my understanding you want to enter a plea today to resolve your case, is that correct?
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, or medication at this time?
No.
Are you suffering from any mental illness or emotional disturbance?
No.
How far did you go in school?
3-year college.
And do you read and write in English?
Yes, I do.
And did you read and understand the constitutional rights contained in your plea form?
Yes.
Did you go over that plea form with your attorney?
Yes.
And did she answer all of your questions?
Yes.
As to count 1, trespass on property after warning, how do you plea?
No contest.
And are you entering that plea freely and voluntarily?
Yes.
You understand that the maximum sentence you could have received for this offense is 1 year in jail?
Yes.
And you understand that by entering this plea, there will be no trial and that I will impose sentence based upon the plea agreement? All right, as to count 1, the court will withhold adjudication, sentence you to 3 days in the Orange County Jail with credit for 3 days' time served. I will impose court costs, and you are not to return to the scene where this incident occurred. Sir, can you afford to make any payments towards your court costs, fees, and fines? All right, given the defendant's lack of ability to pay, the court will reduce all court costs, fees, and fines to a civil judgment. All right, sir, I want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you. All right, Joseph Bates.
We have Bates. Your Honor, we have Mr. Terrell still.
Yes.
Thaddeus Terrell.
So Bates is Terrell, or?
Let me see, you need the booking number?
The booking number? Let me see, it's 220-13486.
He's here. And Your Honor, he's present.
Oh, who's after Terrell?
Oh.
Yeah, because we have one more as the
We have Terrell, then we have.
reset, Your Honor.
You don't have a Terrell?
I don't have a Terrell.
He's a reset from yesterday, Your Honor.
Okay.
Yeah.
Thank you.
All right. Thaddeus Terrell?
Yes, sir.
All right. All right, Mr. Terrell, you've been charged with trespass on property after warning. Defense, were you trying to resolve this case today?
Yes, Your Honor, but because this was a reset, I didn't get an offer from the state or the court. Would either be willing to extend an offer at this time?
State?
Yes, Your Honor. The offer is an adjudication of guilt, court costs, credit time served, and no return to scene.
Your Honor, we'll take that offer.
All right.
We're ready, Your Honor.
All right. Mr. Terrell, just raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth to help you?
Yes, sir.
All right, please lower your hand. All right, sir, could you please state your full name?
That is Terrell.
All right, and Mr. Terrell, it's my understanding you want to enter a plea, is that correct?
Yes, sir.
All right. Are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No, sir.
How far did you go in school?
11th grade.
And do you read and write in English?
Yes, sir.
And did you read and understand the constitutional rights contained in your plea form?
Yes, sir.
And did you go over that plea form with your attorney?
Yes, sir.
And did she answer all of your questions?
Yes, sir.
Did you initial and sign the plea form?
Yes, sir.
As to the charge of trespass on property after warning, how do you plead?
No, not guilty. No contest.
And is your no contest plea being entered freely and voluntarily?
Yes, sir.
Do you understand that by entering this plea, there will be no trial and that I will impose sentence based upon the plea agreement?
Yes, sir.
All right, as to count one, the court will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and require that you not return to the scene where this incident occurred. Mr. Terrell, can you afford to make payments towards your court costs, fees and fines?
No, sir.
All right, I'm going to reduce all court costs, fees, and fines to a civil judgment. I also want to advise you that you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you. All right, Joseph Bates. Hi.
How you doing?
Good. All right, and Mr. Bates, the courts find that there is sufficient factual basis for probable cause as to the soliciting without permit. Defense, if you want to try to resolve this case, the court would offer a an adjudication and credit time served, as well as court costs.
We'll take that, Your Honor.
All right.
We're ready.
All right, sir, could you please raise your right hand to be sworn in? Yes, 2 days, 1 day.
solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right, sir, could you please state your full name?
Joseph George Bates Jr.
All right, and Mr. Bates, do you want to, it's my understanding you want to enter a plea at this time, is that correct?
Yes.
All right, are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No, sir.
How far did you go in school?
High school diploma.
And do you read and write in English?
Yes.
And did you read and understand the constitutional rights contained in your plea form?
Yes.
Did you go over that plea form with your attorney?
Yes.
And did she answer all of your questions?
Yes, sir.
And did you sign that plea form?
Yes, sir.
As to count one, soliciting without a permit, a violation of county ordinance, how do you plead?
No contest.
And are you entering that plea freely and voluntarily?
Yes.
And do you understand that by entering this plea, there will be no trial and that I will impose sentence based upon the plea agreement?
Yes, sir.
All right, as to count one, I will adjudicate you guilty, sentence you to 1 day in the Orange County Jail with credit for 1 day time served. I will impose court costs and no return to the scene where this incident occurred. Sir, can you afford to make any payments towards your court costs, fees, and fines?
Not right now.
All right, I'm going to reduce all your court costs, fees, and fines to a civil judgment. I want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you, sir.
Thank you.
All right, Gerald Brown. All right, and all right, Mr. Brown, the court finds there is a factual basis supporting probable cause for the charge of disorderly conduct, a violation of city ordinance. Defense, if you want to resolve this case, the court would offer an adjudication of guilt, credit time served, no return to the scene, and court costs.
We'll take that, Your Honor.
How much credit does he have? All right, sir, please raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
All right, sir, could you please state your full name?
Joe Brown.
All right, and Mr. Brown, it's my understanding you want to accept the court's plea offer, is that correct?
Yes.
All right, are you under the influence of any drugs, alcohol, or medication at this time?
No.
Are you suffering from any mental illness or emotional disturbance?
No.
How far did you go in school?
High school diploma.
And do you read and write in English?
Yes.
And did you read and understand the constitutional rights contained in your plea form?
Yes.
And did you review this plea form with your attorney?
Yes.
And did she answer all of your questions?
Yes.
And did you initial that plea form?
Yes.
I'm sorry, did you sign the plea form?
Yes.
All right. And do you understand that by entering this plea that you're giving up the constitutional rights contained in that plea form?
Yes.
As to the charge of disorderly conduct, how do you plead?
No contest.
And are you entering that plea freely and voluntarily?
Yes.
Do you understand that by entering this plea that there will be no trial and I will impose the sentence that I previously announced?
Yes.
All right, as to count one, the court will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and you're not to return to the scene where that incident occurred. Sir, can you afford to make any payments towards your court cost fees and fines? Sir, can you afford to make any payments towards your court cost fees and fines?
May I have one moment, Your Honor? Your Honor, we'd be asking for a civil judgment at this time.
All right, the court will reduce all court cost fees and fines to civil judgment. I also want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right. And is this Mr. Diaz-Cordero?
Yes, sir.
All right, Mr. Diaz-Cordero, I do find there is probable cause for the offense of soliciting without a permit, violation of county ordinance. Did the state want to resolve this case? I would note that Mr. Diaz-Cordero was out on bond on possession of fentanyl and possession of drug paraphernalia. The court is not inclined to revoke the bonds on that case.
Your Honor, what would the court's offer be?
How much credit does it have? Adjudication, 2 days for credit time served, court costs, and no return.
We'll take that, Your Honor.
All right. Sir, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right, sir, could you please state your full name for the record?
Yorandia Cordero.
And Mr. Diaz-Cordero, are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No.
How far did you go in school?
8th grade.
And do you read and write in English?
Yes, sir.
And did you read and understand the constitutional rights contained in your plea form?
Yes, sir.
And did you go over that plea form with your attorney?
Yes.
And did she answer all of your questions?
Yes, sir.
All right. And do you understand that by entering this plea, you're giving up the constitutional rights contained in your plea form?
Yes, sir.
And did you sign that plea form?
Yes, sir.
As to count one, soliciting without a permit in violation of county ordinance, how do you plead?
I contest.
And are you entering that plea freely and voluntarily?
Yes, sir.
Has anybody forced or threatened you in order to get you to enter this plea?
No, sir.
And do you understand that by entering this plea, there will be no trial and that I will impose sentence based upon the plea agreement?
Yes, sir.
All right, as to count one, the court will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and you're not to return to the scene where this incident occurred. Can you afford to make any payments towards your court cost fees and fines?
No, sir.
All right, I'm going to reduce your court cost fees and fines to a civil judgment. I also want to advise you that you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you.
Okay.
And take no action on the bonds. All right, Kyle Ferretti. All right, Mr. Ferretti, the court finds that there is a factual basis for the charge of soliciting without a permit, a violation of county ordinance. State, did you want to try to resolve this case? The court would offer adjudication, credit time served, court costs, and no return.
We'll take that, Your Honor.
All right.
Right. You asked the state to bring it up.
Oh, I'm sorry. Defense. All right. Can you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth will help you?
Yes, ma'am.
All right, sir, could you please state your name?
Kyle Ferretti.
And Mr. Ferretti, are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No, sir.
How far did you go in school?
Graduated.
And do you read and write in English?
Yes.
And did you read and understand the constitutional rights contained in your plea form?
Yes, I did.
And did you go over that plea form with your attorney?
Yes, I did.
And did she answer all of your questions?
Yes.
And do you understand that by entering this plea that you're giving up the constitutional rights contained in your plea form?
Yes.
And did you sign that plea form?
Yes.
As to the charge of soliciting without a permit, how do you plead?
No contact.
And are you entering that plea freely and voluntarily?
Yes.
And do you understand that by entering this plea that there will be no trial and I will impose sentence based upon the plea agreement?
Yes.
All right, as to count one, the court will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. That will impose court costs and in order that you not return to the scene where this incident took place. Sir, can you afford to make any payments towards your court costs, fees, and fines?
Not today.
Okay, I'm going to reduce your court costs, fees, and fines to a civil judgment. I also want to advise you that you have the right to appeal the judgment and sentence of this court, and any notice of appeal must be filed in writing within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you. All right, Tony Jenkins.
Yes, sir.
All right, Mr. Jenkins, the court finds that there is probable cause for the offense of unauthorized presence in an unoccupied or unfinished building, violation of city ordinance. Defense, did you want to try to resolve this case? The court would offer an adjudication, credit for time served, court costs, and no return.
Yes, Your Honor.
How much credit is it? Okay. All right.
Correct, Your Honor.
All right. Sir, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth will help you?
Yes.
All right. And sir, could you state your name for the record?
Tony Jenkins.
All right. And Mr. Jenkins, are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No, sir.
How far did you go in school?
High school diploma.
And do you read and write in English?
Yes, sir.
And did you read and understand the constitutional rights contained in your plea form?
Yes, sir.
Did you go over that plea form with your lawyer?
Yes, sir.
And did your lawyer answer all of your questions?
Yes, sir.
Did you sign the last page of the plea form?
Yes, sir.
And do you understand that by entering this plea, you're giving up the rights contained in the plea form?
Yes, sir.
All right. As to the charge of unauthorized presence in an unoccupied or unfinished building, violation of city ordinance, how do you plead?
No contest.
And are you entering your plea freely and voluntarily?
Yes, sir.
All right. And do you understand that by entering this plea, there will be no trial and I will impose sentence based upon the plea agreement?
Yes, sir.
All right, as to count one, the court will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and an order that you not return to the scene where this incident occurred. Sir, can you afford to make any payments towards your court costs, fees and fines?
No, sir.
All right, I'm going to reduce all your court costs, fees, and fines to a civil judgment. I also want to advise you that you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you, sir. All right, Anthony Mosley. All right, Mr. Mosley, I do find that there is a factual basis for the charge of, for probable cause for the charge of disorderly conduct. Defense, did you want to try to resolve this case? It'd be an adjudication, credit for time served, court costs, and no return.
Yes, Your Honor.
All right. All right, so they're going to just hold them? Okay. All right, Mr. Mosley, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
All right, sir, could you please state your name for the record?
Anthony Mosley.
All right, and Mr. Mosley, are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No, sir.
How far did you go in school?
Graduated.
And do you read and write in English?
Yes, sir.
And did you read and understand the constitutional rights contained in your plea form?
Yes, sir.
And did you go over that plea form with your attorney?
Yes.
And did she answer any questions that you may have had?
Yes.
Do you understand that by entering this plea that you're giving up the constitutional rights contained in the plea form?
Yes, sir.
As to count, and did you sign that plea form?
Yes.
As to count one, disorderly conduct, how do you plead?
No contest.
And are you entering that plea because you believe it's in your best interest?
Yes, sir.
And are you entering your plea freely and voluntarily?
Yes, sir.
And do you understand that by entering this plea, there will be no trial and that I will impose sentence based upon the plea agreement?
Yes, sir.
All right, as to count one, the court will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and an order that you not return to the scene where this incident occurred. Can you afford to make any payments towards your court costs, fees, and fines?
No, sir.
All right, I'm going to reduce your court costs, fees, and fines to a civil judgment. I want to advise you that you have the right to appeal the judgment and sentence in this case. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you. All right, Wendy Williams.
She's here, Your Honor.
All right. All right, Ms. Williams, the court finds that there is a factual basis for a probable cause, for a finding of probable cause for unauthorized presence in a non-occupied or unfinished building, a violation of city ordinance. Defense, if you'd like to resolve the case, the court would offer an adjudication of guilt, credit for time served of 2 days, court costs, and no return to the scene where this incident occurred.
Your Honor,
Yes.
we would like to take that offer, but we would also like for the court not to take any action on the case that she's out on bond for.
All right, she was out on bond for a petty theft in 22 MM 3770 state.
They asked that this court revoke the bond.
All right, the court is not inclined to revoke the bond on the petty theft. She is on PTR. And the affidavit indicates that the theft related to her being in that unoccupied or unfinished structure. Okay?
Your Honor,
All right.
ready?
All right, ma'am, could you please raise your right hand to be sworn in?
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you?
All right, could you please state your full name?
Brenda Williams.
All right, and Ms. Williams, it's my understanding you want to enter a plea today, is that correct?
Yes.
Are you under the influence of any drugs, alcohol, or medication at this time?
No.
Are you suffering from any mental illness or emotional disturbance?
No.
How far did you go in school?
10.
And do you read and write in English? And did you read and understand the constitutional rights contained in your plea form?
Yes.
And did you review that plea form with your attorney?
Yes.
And did she answer all of your questions?
Yes.
You understand that by entering this plea, that you're giving up all the constitutional rights contained in that plea form?
Yes.
And with regards to the sentence that the court will impose, are you entering your plea freely and voluntarily? Did you sign the plea form, ma'am?
Yes.
As to the charge of unauthorized presence in an unoccupied or unfinished building, a violation of city ordinance, how do you plea?
No content.
And do you understand that by entering this plea, there will be no trial and that I will impose sentence based upon the plea agreement? All right, as to count one, I will adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs, and you'll be required not to return to the scene where this incident occurred. Ma'am, can you afford to make any payments towards your court cost fees or fines? I'm going to reduce all your court cost fees and fines to a civil judgment. I also want to advise you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you at no cost. All right, thank you, ma'am. And with regards to the petty theft, the court will take no action on the bond that she was currently out on. All right, I believe that concludes initial appearances. Do we have any over there that were left?
No, Your Honor.
All right, thank you. Oh, wait, hold on.
Amy James.
Yes.
Okay,
No, that was reset for tomorrow. All right, thank you. We'll be in recess.
Thank
you. Thank you. All right, let's go ahead and get started. Christine Beck.
We're going to stand right up for reference.
All right, could you please state your name for the record?
Christine Beck.
All right, Ms. Beck, the court has been provided with an affidavit which states that you committed the offense of grand theft of a motor vehicle. The court finds that there is probable cause for that offense. Defense with regards to release, did you wish to be heard?
Yes, Your Honor, just that Ms. Beck is entitled to a reasonable bond. A high bond is equivalent to a no bond. I'd be asking for a reasonable bond in this case.
All right, and state bond is currently set at $2,500.
That's at the bottom, made that's
All right, the court will appoint the public defender, leave the bond as previously set at $2,500. The court will impose the conditions that you have no contact with the victim, and that you not possess any weapons, firearms, or ammunition.
Yes, sir.
Niama Brown.
Your Honor, will you be taking action on Ms. Beck's case, open cases? Go back.
I'm sorry. Let me see. Which open cases? I don't have a sheet on this one.
She's out in 22 CF 1165 for heroin possession, possession of methamphetamine, drug equipment. She did bond out on 5/11/22.
All right. And defense, you wish to be heard with regards to whether the court should revoke bond? The court would note that in the affidavit, it was stated by this defendant that she was checking herself into a rehab facility when she was in possession of the vehicle. Did you wish to be heard with regards to revocation?
Yes, Your Honor, just that she was taking responsibility in regards to trying to get help based on her addiction, I would ask if the court would take no action as to the 22 CF 1165. Therefore, if she does bond, she can get that help that she's trying to get.
All right, and what's the state's position?
No objection, Your Honor, to that.
All right, so the court will take no action as to the bond on the possession offense. All right, thank you, ma'am.
Thank you.
All right, Niyama Brown. All right, ma'am, just state your name.
Naima Brown.
All right, Ms. Brown, the court finds that there is probable cause for the offense of battery. This is alleged dating violence. I will appoint the public defender to represent you. Bond is currently set at no bond. She is eligible for PTR with bond. Defense with regards to release, what are you asking the court to do?
Yes, Your Honor. Ms. Naima Brown is entitled to a bond based on the charge. I have spoken with Ms. Brown. She is a college student and not working, doesn't have any priors. I'd be asking if the court would consider an RR based on the facts of the case, if not a reasonable bond in this manner.
I'm sorry, state?
The state would ask for a $500 bond, Your Honor.
All right, I'm going to set bond in this case at $100 with PTR. The conditions of bond is that you have no contact with the victim in this case. It should not possess any weapons or any firearms or any ammunition.
Thank you, Your Honor.
Thank you.
All right. Charles Causey.
Your Honor, he refused, based on this is the first time, I'd ask for a 24-hour reset.
All right, he's got 2 cases. You want me to reset both of those cases for tomorrow? Defense?
Yes, Your Honor.
Okay. We'll reset both of Mr. Causey's cases for tomorrow. I'm sorry, it looks like he's got 3 cases, actually.
Yes, Your Honor.
3, so we'll reset all 3, 24-hour reset on all 3 cases. All right, Miguel Clausel. All right, sir, please state your name.
Miguel Clausel.
All right, and Mr. Clausel, the court finds based on the affidavit provided that there's probable cause for the offense of battery. And this is domestic violence. And PTR, is he eligible?
Your Honor, we were unable to verify his history. His fingerprints have not come back yet. So at this time, he does not qualify.
All right. Defense with regards to release?
Judge, he's entitled to a bond based on the charges. I'd be asking for a reasonable bond in this case. As previously stated, a high bond is equivalent to a no bond, so I'd be asking for a reasonable one.
State?
We'd ask for a $500 bond, Your Honor.
All right, the court will set bond at $500 with the following conditions. He's not to have any contact with the victim. He's to maintain a separate residence. He's not to possess any weapons, any firearms, or any ammunition. He will be allowed to return to the residence on 1 occasion to retrieve any personal belongings, as long as he's accompanied by law enforcement.
Thank you, Your Honor.
This is fine.
$500. Sean Cotton.
Good morning,
Yes,
sir.
please. Good morning. Could you please say your name?
Sean Cotton.
All right, Mr. Cotton, the court finds that there is a basis for probable cause based on the affidavit provided for the charges of abuse of an elderly person without great bodily harm, and 2 counts of that offense. Bond was set at 0. Defense, do you wish to be heard with regards to bond?
Judge, defense would just be asking for a reasonable bond. He's entitled to bond in this case.
All right, and state?
The state is asking for a $1,000 bond for each charge, Your Honor, a total of $2,000.
All right, the court will set bond on count 1 at $2,000, on count 2 at $2,000. The conditions of bond will be as follows. The defendant is to have no contact with the victim in this case. Is not to return to the residence. I'll give him a one-time return with regards to any personal belongings, as long as he's accompanied by law enforcement, no weapons, firearms, or any ammunition.
Thank you, Your Honor.
2,000, count one, 2,000. Raul Navarro. All right, sir, state your name.
Raul Navarro Jr.
All right, Mr. Navarro, in 2021 MM2230, there was a warrant for your arrest on a failure to appear. The bond in that case was set at zero bond. Will appoint the public defender, leave the bond set at zero bond. In 21 MM2232, you failed to appear. In that case, there was a warrant issued. The bond in that case was set at zero bond. I will appoint the public defender and leave bond as previously set. In 21 MM2233, there was a warrant for your arrest on a failure to appear. Bond was set at zero. In that case, the court will leave the bond as previously set and appoint the public defender. In 21 MM2234, there was a warrant for your arrest, failure to appear. Bond was set at zero. The court will leave it as previously set and appoint the public defender. And in this case number on this one.
He has one more case, sir.
Yeah. There's no case number on this, but bond, it's alleged that on June 11th, that you were in possession of methamphetamine as well as drug paraphernalia. The court finds that there's probable cause with respect to those offenses. Defense, bond was set at $2,500 on count one, $500 on count two. Did you wish to be heard with regards to release?
Judge, I'd just be asking for a reasonable bond in this case, being that he is appointed to the public defender. He's not, doesn't have the means for a bond. I'd be asking for a lower bond, at least in count one.
All right, state.
The state would ask for the bonds to remain as set, Your Honor.
All right, as to count one, the court will reduce the bond to 1,000. As to count two, the court will reduce the bond to 100. Conditions of bond: no possess any drugs or any medications unless you have a valid prescription. No weapons, no firearms, no ammunition. All right. Reggie Paulino. All right, sir, please state your name.
Reggie Paulino.
All right. And Mr. Paulino, it's alleged that you violated, or there's an affidavit indicating that you violated the law with regards to battery, domestic violence. The court finds that there is probable cause. With regards to bond, defense, you wish to be heard.
Judge, in regards to bond, I would ask for a reasonable bond in this case, being the nature of the circumstances. I would also ask for the court to consider whether or not we can identify if the alleged victim in this case is still living in the household, being that they both lived in the household together. But besides that, I would just be asking for a reasonable bond.
All right, and state?
The state would be asking for a $500 bond, Your Honor.
All right, he's eligible for PTR. The court's going to set bond at $100 with PTR. The conditions of PTR is that he maintain a separate residence, that he have no contact with the victim. Obviously, any paperwork that's submitted through the court is not a violation of that order, Mr. Paulino. So if you're filing paper with the court and that's being sent to her, that's fine, but you cannot contact her directly to discuss any issues with regards to your divorce. Do you understand that?
Yes.
All right. All right. You're not to possess any weapons, any firearms, or any ammunition. And the court will allow a one-time return to the residence accompanied by law enforcement to retrieve any personal belongings. All right. Aladino Podestad.
Good morning, Your Honor.
Good morning. Could you say your name?
Aladino Potestad.
All right, Mr. Potestad, the court finds that there is probable cause in the affidavit provided for the charge of aggravated assault with a deadly weapon. Defense, you wish to be heard with regards to bond, and he's eligible for a PTR with bond.
Yes, Your Honor, I'd be asking for a low bond in this case, looking at the facts of the case and being that it's a he said, she said type of case. I would be asking for a reasonable bond, and being that it's run by PTR, a lower bond.
All right, and state?
Due to the nature of the crime, Your Honor, the state is asking for a $5,000 bond.
Because he's eligible for PTR, the court's going to set bond at $2,500 with PTR. The conditions of PTR will be that he not possess any weapons, any firearms, or any ammunition, that he not have any contact with the victim, that he not return to the residence or maintain a separate residence. He will be allowed to return to the residence on one occasion to retrieve personal belongings, so long as he's accompanied by law enforcement.
Thank you, Your Honor.
Thank you. William Sanabria?
Judge, just in case, is the public defender appointed in the previous case?
I'm sorry, the public defender is appointed in the previous case. All right, sir, could you please state your name?
William Sanabria Jr.
All right, Mr. Sanabria, you have two cases. In the first case, the court, that there is probable cause with respect to the offense of failure to redeliver a hired vehicle. I will appoint the public defender to represent you in that case. Bond was set at $1,000. The court would note that the defendant does qualify for direct PTR. Defense, you wish to be heard with regards to release?
Yes, Your Honor, I'd be asking for the court to consider direct PTR being the nature of the charges.
State?
The state would ask for the bond to remain at $1,000.
All right, the court will grant the defense's request and place him on direct PTR. The conditions of direct PTR is that he have no contact with the victim, that he not drive unless he possess a valid driver's license, and that he not possess any weapons, firearms, or ammunition. His second case, the court finds that there is probable cause for the charge of driving with a suspended license, a third or subsequent violation. Again, he does qualify for PTR. Defense, you wish to be heard with regards to bond?
Yes, Your Honor, I'd be asking for direct PTR again based on the nature of the charge.
All right, state?
No objection, Your Honor.
All right, as to that offense, the court will place him on direct PTR. The conditions will be the same, that he not drive without a valid driver's license, and that he not possess any weapons, firearms, or any ammunition. All right, thank you, sir. All right, Maria Serrano Montealegre.
Your Honor, she's going to need a Spanish interpreter.
All right, we'll pass this to the end. All right, Wilmer Urbina Reyes.
Your Honor, I'd be waiving the reading of the charges.
All right.
And he is approaching. Also, Your Honor, while he's approaching, I do have a probable cause argument. Your Honor, may I be heard?
You may.
Your Honor, defense asks, or defense feels that there is no probable cause in regards to this case. Looking at the alleged charge, they're lacking the age of the alleged victim in this case based on the lack of facts in this arrest affidavit. It doesn't rise to the level of probable cause as to the charge that they're trying to state that Mr. Urbina Reyes has allegedly committed. I'd be asking for ROR.
All right, state?
Your Honor, we would ask for a 24-hour reset to get the age of the victim.
All right, and defense?
Judge, I know that, I don't have a legal objection. I know they're entitled to 24-hour reset.
All right, the court will reset this 24 hours for the state to provide PC with regards to victim's age. Monique Wolf.
Good morning, Judge.
Ma'am, good morning. Could you please say your name?
Yes, Monique Arlette Wolf.
And Ms. Wolf, the court has been provided an affidavit which establishes probable cause for the offenses of grand theft auto and criminal mischief of $1,000 or more. The defendant does not qualify for PTR. I will appoint the public defender and defense with regards to bond. They're currently set at $5,000 on count one, $2,000 on count two. Do you wish to be heard?
If I can have a moment, Your Honor.
You may.
Sorry, Your Honor, the button here is broken. I would be asking for a reasonable bond in this case.
All right. And state, with regards to,
Your Honor, the state would ask for the bond to remain as set.
okay. I just want to make sure that there's PC for the grand theft auto. This appears to be a golf cart. It doesn't indicate whether the golf cart meets the requirements of the motor vehicle.
Clarification, Your Honor, you have concerns about whether the golf cart qualifies as automobile audit chart?
Yes. It's really loud. Go ahead.
In that case, Your Honor, the state would ask for a 24-hour reset to research that issue.
All right. As to count one, or we reduce the bond to $2,500. As to count two, or we'll reduce the bond to $1,000. This will be reset for tomorrow. For the state to establish PC with regards to whether or not the golf cart constitutes a motor vehicle. The golf cart constitutes a motor vehicle, whether it's a motor vehicle or not.
Thank you, Your Honor.
Thank you.
It's going to get reset tomorrow.
All right. Jonathan Padilla. All right, and could you say your name?
Jonathan Padilla.
All right, Mr. Padilla, there's a warrant for your arrest out of Polk County. Bond in that warrant was set at $4,000. The court will provisionally appoint the public defender. If you can't afford that bond, you can request that the judge in Polk County who's presiding over the case consider a reduction, all right? All right, April Marie Brown. All right, ma'am, could you say your name?
April Marie Brown.
All right, Ms. Brown, you have two cases. In the first case, the court finds that there's probable cause for the charge of possession of a controlled substance without a prescription and possession of drug paraphernalia. Defense, I'm going to appoint the public defender. Do you wish to be heard with regards to release?
Yes, Your Honor. Based on the nature of the charges, I'd be asking for a reasonable bond in this case.
All right, state.
State would ask that the bond remain as set, Your Honor.
All right, the court will reduce the bond on count one to $1,000. Count two will remain as previously said. The conditions are that she not have possess any drugs, alcohol, or any medication without a valid prescription, that she not possess any weapons or any firearms. As to the other case, the court finds that there is probable cause for the charges of possession of a controlled substance without a valid prescription, as well as possession, another count of the same, possession of controlled substance, and that there's probable cause for possession of drug paraphernalia. Defense, did you wish to be, the court will appoint the public defender, did you wish to be heard with regards to bond?
Yes, Your Honor, I'd just be asking for the same bond as the previous case.
All right, state.
Objection, Your Honor.
All right, the bond on count one will remain at 1,000. Bond on count two will remain at 1,000. Bond on count three will be reduced to 150. The conditions of bond will be that she not possess any drugs, alcohol, or medication without a valid prescription, and that she not possess any weapons or any firearms. All right. Robert Hutchinson.
Your Honor, I would waive his appearance.
All right, I will appoint the public defender to represent him. Bond was set at $7,500 on count one, $150 on count two. The defense wish to be heard with regards to those bonds.
Your Honor, if the court would consider lowering the bond, I'd be asking for that, but I just ask for a reasonable one.
State.
State would ask that the bonds be remain as set, Your Honor.
Given the facts of this case, the court will leave the bonds as previously set. The conditions of bond would be that he not possess any drugs or medication without a valid prescription, and that he not possess any weapons or any firearms. And we're just waiting on the interpreter on Serrano Montealegre, and we'll call that up in a few moments.
Thank you, Your Honor.
So, Pastor, what do you do with the activity? What about that attorney? Does she know?
No. She didn't have a power of attorney.
I think he was under talking to somebody on the booking pool, I mean, down in Transit.
Oh, that was right.
Before we pulled him.
Okay.
Jackson Blair?
Is he gonna get out?
There,
Is the attorney gonna be over there for here? Because he was here, the traffic was talking.
Yeah.
Yeah. Here's where it comes from. Should-
get no document. Somebody for even already. What? Oh, you already gave some? Oh.
I was upstairs doing that when I was
Hey, you know that wheelchair girl you move up?
Oh, we check the real, one way check.
Yeah, she's in a wheelchair. Just one.
Yeah.
Oh, I don't know what people in the wheelchair.
It was, Tiffany Williams, phase 2.
Okay.
Okay.
I think that's her name.
Receive it.
I don't know if they have a big.
If so, she be pulled up because.
That was Tiffany Williams.
Tiffany Williams. You had her to move up?
No.
Oh, we didn't have her do, I didn't, wheelchair. Maddie should move up.
I'm asking if you added her.
Oh, you added her?
Yeah. Yeah. Okay.
How can I get judge?
Put her on there. Tell her she can move up. 'Cause she's
I
like,
like the judge.
huh?
I told the judge, I don't have an act. Yeah, what I'll do, we'll put her at the end.
Okay.
I'm gonna move up, so.
Come on, fly her over. What's up with DeMarco? She said DeMarco's coming. Who's that? Or is it?
Yeah, that's right.
Is that- is that good?
Cause she's gonna come in about domestic, so.
Oh, DeMarco is going on too.
Tiffany.
That was the girl.
She's, she did a wheelchair. So she'll be after the move us.
So down here?
Tiffany, she's on felony domestic.
They still have one in, I was able to,
Oh, he's got one?
Spanish speaker.
Oh, okay. I put it in already.
They were trying to get the.
I did my pocket. You're all right. Sorry.
All right, and Madam Interpreter, could you raise your right hand to be sworn in? Do you solemnly swear that you will and truly interpret from Spanish to English and English to Spanish to the best of your ability? All right, thank you. All right, Maria Serrano Montalegre, please say your name for the record.
Señora, por favor, dígame su nombre para las actas.
No lo escucho muy bien.
Díganos su nombre para las actas, por favor.
María Alejandra Serrano Montealegre.
María, repita, por favor.
María Alejandra Serrano Montealegre.
María Alejandra Serrano Montenegro.
All right, and Ms. Serrano Montealegro, the court finds that there is probable cause for the offense of battery, domestic violence.
Señora Serrano Montenegro, el juez halla que hay causas que respaldan la acusación de agresión, violencia doméstica.
All right, and with regards to release, I'm going to appoint the public defender with regards to release, defense, you wish to be heard.
El juez le pregunta al abogado defensor público si tiene algo que decir en cuanto a las condiciones de libertad.
Yes, Your Honor, being the nature of the circumstances and the minute alleged battery in this case, I'd be asking for a low bond, if anything, $100 bond in this case. She does qualify for PTR, and I do not believe she has a history.
All right, State.
No objection, Your Honor.
La abogada de la defensa ha pedido una fianza mínima dado a el caso de agresión minuto que se alega y la acusada es elegible para el programa de libertad preventiva. El fiscal no se opone a tal.
PTR.
PTR.
PTR, is there anything you wanted to add?
Se le
Your
pregunta
Honor,
al programa de libertad preventiva si hay algo que quieran añadir.
Your Honor, at this time, after further investigation, she doesn't qualify for PTR. However, she does not have any history.
Su señoría, después de haber indagado un poquito más, ella no es elegible para el programa de libertad preventiva, pero no tiene antecedentes penales.
Judge, she actually, I was talking to PTR before. She was going to qualify, however, it looks like they're waiting for immigration status. If it comes through, then she does qualify for PTR. Again, if it wasn't for her immigration status, if it wasn't for immigration status, then she would have qualified, and I'd still be asking for $100 in this case.
Su señoría, yo había hablado con el agente del programa de PTR anteriormente y aparentemente ella calificaba, pero están esperando información de inmigración. Si ella no tiene el problema de inmigración, sería elegible para el programa de libertad preventiva. De lo contrario, estaría pidiendo una fianza como quiera baja de $100.
State.
Fiscal.
Your Honor, the state would still ask for a bond, whatever the judge sees fit in this case.
Su señoría, el fiscal como quiera está pidiendo una fianza de acuerdo a lo que el juez piense que es adecuado en este caso.
All right, the court will set bond at $100 with the following conditions.
Bien, se va a establecer una fianza de $100 con las siguientes condiciones.
Defendant will not return to the residence.
La acusada no puede regresar a la vivienda.
No contact with the victim.
No puede tener ningún tipo de contacto o comunicación con la víctima.
No weapons, firearms, or ammunition.
No puede poseer ningún tipo de armas, armas de fuego, municiones.
And the court will allow one-time return to the residence, accompanied by law enforcement to retrieve any personal belongings.
El juez le va a permitir regresar a la vivienda una sola vez, en una sola ocasión, acompañada con un agente de la policía para retirar sus artículos personales.
All right, thank you.
Bien, gracias.
Thank you, Your Honor.
And that concludes Osceola initial appearances. We'll be going over to Orange County and starting the interpreter cases.
Thank you, Your Honor. Have a good day.
You too.
Thank you.
All right, and BRC can, we don't have a video. Make sure the camera's on.
Oh, the button? Hold on.
No, not the button.
Hold on, Your Honor.
Okay.
Oh, you know what? This.
Yeah, you got the
That's what
photo
it is.
too.
All right, we've got video now. Thank you.
You're welcome, Your Honor.
All right, and do you have Eliana Espinoza in the courtroom?
Yeah. One moment, Your Honor.
One moment, Your
Walk
Honor.
away.
All right. She is the victim in the Claudio Perez case, so we're just going to call him up, have her sworn in, take her testimony, and then we'll address her cases as well.